Everyone, it is 11:50. I'm going to go ahead and call this Kuwaitan Casino Gaming Authority meeting to order. We'll start with roll call, please.
Bridget Sorensen. Here. Aaron Paymont.
Here.
Larry Barbeau.
Here.
Kimberly Lee. Here. Michael McCurchie. Kimberly Gravel.
Here.
Sean Borowitz.
Here.
Tyler LaPlante.
Here.
Kimberly Hampton. Lana Cosley Smith.
Here.
Isaac McKechnie.
Here.
Rob McGrory. Here. Austin Lowe's.
Here. Okay, everyone, we have a quorum on today's.
Excuse, Kim and Mike.
So is there any objection to excusing Kim and Mike's absence today? Hearing no objection, those absences will be excused. On today's proposed agenda, we have meeting minutes from 3:24 of 26 and 3:27 of 26, and we have the following resolution. It's titled FY26 CapEx Modifications / Authorization to Execute Capital Reinvestment Projects. Is there a motion to accept the agenda? Support. Motion from Isaac, support by Larry. Any discussion on the proposed agenda? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries and the agenda is adopted. That brings us to our first item, which are minutes. I'd like to entertain a motion to accept the minutes from 3:24 of 26 and 3:27 of 26. Support. Motion from Isaac and support by Larry. Any discussion on either set of minutes? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries. That brings us to our one and only resolution. It's titled FY26 CapEx Modifications / Authorization to Execute Capital Reinvestment Projects.
Be it resolved by the Management Board of the Kuwaitan Casinos Gaming Authority hereby approves the FY 2026 modification capital expenditures budget and authorizes executing the capital projects that promote longevity, stability, safety, and/or profitability for Kuwaitan casinos listed in Attachment A in accordance with the recommendations as a result of the feasibility study that was completed in 2025. Be it further resolved by the Management Board of the Kuwaitan Casinos Gaming Authority hereby authorizes the chairman to delegate signature authority to the CEO and CFO to approve all purchasing documents and vendor contracts procured according to applicable purchasing policies.
Motion by Isaac. Support. Support by Larry. Al, could you explain this resolution to our membership? So obviously we worked with a company to do a feasibility study who determined if we allocate the resources that we had towards these projects, it would yield the quickest return on investment and the best return on investment for the tribe. Just go into as much detail as you can, and then we'll open up to a board discussion.
Okay, well, I appreciate that feedback, but that's exactly what we did. We hired a company to come in and give us a feasibility study on what projects we could entail in the next 3 years that could have the quickest return on investment. We had them do the study in 2025. They provided feedback and a list of opportunities, I'll call them, for us to have the quickest return, which would drive additional revenues to all 5 of our properties. Now, these projects entail RV parks, upgrades to hotel, upgrades to F&B, and other ancillary projects, but those projects have the quickest return on investment as far as ROI and revenue, another revenue stream for us to have at each and every one of our 5 properties.
Okay, thank you, Al. Board discussion, start with Bridget.
I'd like to make a motion to amend to include the total expenses on the resolution, or the dollar amount.
Of all the projects?
Yes, the total dollar amount of the projects.
All projects, okay. Is there a second? Okay, so there's a motion and support to amend this resolution to include the final dollar amount for all projects. Any discussion here? Kim?
Is there a downside to putting that on the reso?
I don't think so. I mean, it's listed out, each project is listed out with estimated cost.
I'll just tell you the reason we didn't is that resolution that mandates to put on the fund, the cost center and the total funds has a carve out for proprietary information. When we drafted this resolution, we were talking with Kuwaitan and we deemed it to be proprietary information is why it was not included in the resolution. But if Alan thinks there's no harm, then I will defer to him. But that is the reason that we did not put this on, and the reason we typically don't for Quaden and/or Enterprises.
Okay, that's
Just
what I
so you know
wanted-
why it wasn't there.
Yep.
Yep.
Okay, that's why I wanted to know.
Okay, any issue, Al?
No, I mean, it's public consumption. It's in the 60s altogether, but
Okay,
it's all itemized out, though. Each project is listed with an estimated cost.
yeah.
Yeah. Yeah, okay.
Okay, Aaron?
Yes, broadcasting to our competitors what our CapEx budget is not smart, so I'll be voting no on the amendment.
Okay, anyone else? Okay, so it's just gonna have the dollar amount. It won't specify the fund source, whether it's iGaming, whether it's CapEx. So final opportunity for questions. Bridget?
So I just think that the dollar amount doesn't tell anybody what we're doing. It's just telling the membership what we're putting back into our properties. I'm sure at some point we're going to have our PR person go out and get everyone excited about the possible renovations at that time. So putting the dollar amount out there, I don't think gives anybody a heads up on what we're going to do as far as our business.
Okay, thank you. Anyone else? Okay, so we're gonna roll call the motion to amend, and this would just publish basically how much these projects are gonna cost.
Tyler.
Yes.
Sean. Kimberly Gravel. Lana.
Yes.
Isaac.
No.
Larry.
Yes.
Kimberly Lee.
Yes.
Rob.
Yes.
Aaron.
No, wait.
Bridget.
Yes.
Carried.
Okay, motion to amend successfully carries. That brings us back to the resolutions. Any questions, comments before we vote? Okay, hearing none, roll call, please.
Kimberly Lee.
Yes.
Isaac.
Yes.
Rob.
Yes.
Bridget.
Forget name.
No. Aaron.
Yes.
Tyler.
Yes.
Lana.
Yes.
Larry.
Yes.
Sean.
No.
Kimberly Gravel.
Yes.
Okay, motion carries. That concludes all the items that we had for today's Gaming Authority meeting. Without objection, meeting adjourned. Seeing no objection, meeting adjourned, and we will take our lunch recess for the day and be back in session at 1:15. So see everyone then.
The recording has stopped.
Everyone, let's get back to work. The item that we're currently on is proposed constitutional amendment. Our General Counsel, Ryan Mills, is here to provide us with an update and where we are in that process. We're obviously been working for quite some time on having a secretary election conducted by the BIA. We went through several rounds of revisions to the last proposed constitutional draft, and you have an update to provide.
Yeah, we got back from the local Bureau of Indian Affairs office their informal reviews. In your packet, you have a memo where I've copied and pasted their reviews into a memo for readability. You also have their email straight from the BIA that has all their comments in your packet. We'll go through each article. They've made comments. Some of them are no issues noted. Some of them they have clarifying questions. So we'll go through the memo in each article of the draft constitution amendments, and we'll let you know the BIA feedback, our proposed response to that feedback, and then we can poll you guys, and if you agree with that response, and that will get incorporated, if you all agree today, into the draft amendment to go back to the BIA for the regional office to do a layer of informal review. Any change that we make today will update to the one on the website. The one on our website that has the summary, the red line, and the clean version, that is the last board-approved draft amendment. That's also the one that BIA is working off of. There has been no changes since then because we were waiting on the BIA to give us their feedback.
And we obviously knew that we'd receive several rounds of feedback, so this is that first round after we get done implementing whatever we're going to implement. We punt it off to the BIA, and then the regional office gives us their feedback, and then
Yes.
we do the same thing, and then it's on to the next step.
Correct, and this is set on for the workshop on May 5th, but we won't have the regional feedback by then probably. It was set on that date per the resolution that set those timelines as the tentative date where we would workshop the final version and vote on it. But it's all dependent on the BIA review. And so under that resolution, we have 30 days after the final review of the BIA informal review to then trigger the board directors to vote on it.
Okay, very good. Let's get started.
All right. So I got it up on the screen here. You'll see at the very top here that this is the BIA informal review of the proposed changes / amendments to the Sioux Tribe Chippewa Indians Constitution and bylaws. Their overall comments are that it does not appear to have any language that is contrary to federal law, nor does there appear to be contrary articles or language that mute or hold irrelevant any other article within the Constitution or bylaws. So one of the big things the feds look for are if something in our Constitution that may be contrary to the federal Constitution, Bill of Rights, or federal law that is applicable to tribes, they would flag that for us. They also look to see if we have Article 3 that conflicts with Article 7, they'll flag that sort of things. They said none of those overall things were flagged, so that means that none of our articles in their mind contradict with each other, nor is anything contrary to law. And then we'll go down through each section of the Constitution, starting with the preamble. They noted that this was a total rewrite of the preamble. We rewrote it based on the 2008 and 2012 versions of the Constitution. It needed to be rewritten to encompass some of the changes later on. But they had no issues noted on our preamble. Article 1 is our sovereignty statement, new article, total rewrite, because it's not an article that's currently in that form in our Constitution. But as we separate out our government, we need to have a strong statement of that sovereignty. No issues noted. Article 2, our territory and jurisdiction article. This is where we expressly state where our jurisdiction extends to our citizens and to our lands. They had no issues noted on that section either. Article 3, citizenship. New article, this is their notes, new article / title, right? We change it from membership to citizenship. Change it from 6 historic bands to 7 historic bands. Change board of directors to tribal council. The BIA had no issues noted on that change. Article 4, our Bill of Rights. New article, new title, total rewrite. It's our own version of our Bill of Rights. It also incorporates the federal Bill of Rights. No issues noted. Article 5, separation of powers. BIA notes, of course. It's a new article, new title, total rewrite. This is the article that states we are creating 3 separate co-equal branches of government. No issues noted. Article 6, judicial branch, new article, new title, total rewrite. This enumerates all the powers, obligations, authority, etc. of the judicial branch as a co-equal branch of a 3-branch government. No issues noted. Article 7, legislative branch, new article, title, total rewrite. The issues, questions follow as such. In Article 7, Section 6M, in the red lines of our draft Constitution amendments, there's language that gives the executive branch power over the duly enacted authorities pursuant to H. It was a typo. It should be pursuant to little I. And so our response to their issues question is we will edit Section 6M that currently cites to H and correct it to cite to I. It was just a clerical correction.
So this is just clerical. Any objection to Ryan going ahead and changing it to reflect all that? Okay, hearing no objection, that's your direction, Ryan.
Article 8, executive branch, new article, new title, total rewrite. Issues, questions as follows. There's a clerical issue where Section 4 has 2 Bs. And the question was, are they combined into one section, or are they supposed to be 2 different subsections? Please correct as needed. And then Article 7, Section 5F, they ask what authorities. The wording doesn't seem to flow. There's difficulty understanding the intent. So our response to that, starting with the clerical error for Article 7, Section 4, we fixed the formatting, so now it has 4B and 4C, et cetera, instead of double Bs.
Any objection to Ryan changing that to clean it up? Okay, no objection, Ryan.
The second issue they flagged, Article 7, Section 5F, we are proposing correcting that by separating these out so it's more clear into as follows. The A here, the power to appoint members to the governing bodies of the authorities created by the tribal council pursuant to Article 7, Section 6I, subject to confirmation and approval by tribal council. I believe this cleans up the ambiguity that the BIA noted as what articles or what authorities. So now it's shooting back expressly. The executive has the power to appoint members to the authorities that the tribal council has the power to create in Article 7, Section 6I. I'll pause on that one.
Any objections there, based on Ryan's recommendation? Okay, no objection, Ryan.
And then we've separated out, these were combined previously. The second part of that is the power of the executive to appoint key executive positions of the tribal government, subject to confirmation and approval by tribal council. I just think it's cleaner to have the authority power in one section, the executive position power in the other. It didn't change the intent. They were combined into one paragraph. Now they're 2 paragraphs. So I'll pause if there are any questions on that second paragraph.
Is everyone okay with that? Okay, let's go that route.
Article 9, our resignation, recall, removal, and vacancy section. BIA notes it's a new article, new title, total rewrite. No issues noted. Article 10, nominations and elections. BIA notes, new article, new title, total rewrite. Issues, thus grammar errors to follow. In Article 10, Section 1, the 5 voting units, the 5 voting as units of the tribe is a grammar error. Suggestion is to remove the word as, so it reads, the 5 voting units of the tribe, et cetera, et cetera.
Any issue? No issue, Ryan?
Their next question, suggestion, is a little longer. It comes from Article 5, Section 4, voting unit. There's a requirement, right, that those members residing in a unit, they reside in one of our 5 units, they must vote, must vote in that unit. Whereas those members not residing within a unit, the at-large members must register to vote within a unit. BIA notes that it appears clearly if you reside in a voting unit, that is of course the unit you vote in. However, it appears potentially that a person not residing within a unit would have the ability to register in a given unit for one voting cycle and then register to vote in a different voting unit the next voting cycle, thus allowing for, quote, unit hopping. The question from the BIA, is there any idea that this language would indicate once you register in a unit for non-residing members that they would be the unit that would be the unit you vote in every time unless you physically move into a different unit? Likewise, same criteria for those living in a unit. They vote in that unit unless they move to a different unit or move outside the voting units, thus having to register for the unit of their choice. And that, I believe, was the intent. Our current code disallows unit hopping. Once you are registered, if you live in Detroit, you register in Unit 1, you are registered in Unit 1 for the entirety of your time as a voter, unless you move up here to the EUP into one of our units. And so I'll wait. I see Robert has a question, but I have some language I think maybe clarifies the intent a little more.
Yeah, I have Tyler, Rob, then Bridget.
So I have 2 things. One, I like your response here. It's already in code. Is code good enough for the BIA? Does it need to be in the Constitution? Because it wasn't in our previous Constitution. And then 2, after hearing you read that, I don't think we should call them units anymore. We should call them districts or regions or something else, because that doesn't sound good saying it 20 times in a sentence. And it makes me really focus in on the word unit and how it really doesn't align with who we are.
And we
Right.
did have, Tyler, we did at one point earlier this year, maybe late last year, I can't remember. We had it as districts because it was as districts in the 2008 draft.
Yeah.
And we switched it back to units to be consistent with our code. I had no strong opinion either way.
I think
at
our
the time,
code should be consistent to meet our
Correct.
Constitution and not the other way around. So
agree.
I do remember that discussion. I don't remember it losing in the vote. So like, I just want to kind of highlight that and just hope that we'd be willing to, I mean, it's minimal. It's something little, but hearing you say it 20 times, I'd rather hear district, unit, or region.
Yeah.
It was bad. But I think, you know, your response here is perfect to the BIA, and we don't want to put everything in the Constitution, right? In case those who come after decide to change code to align better with the new structure.
Yeah, I don't believe this needs to be that explicit in the Constitution, right? We're trying to strike that balance of not being overly explicit in Constitution and not being too vague, but being vague enough where the codes rightfully can flesh out how that is to be implemented. If we do change it, I do have some language that we can consider, but I think because our code implements our Constitution, that it's not necessary to be that strict in our Constitution.
Okay, thank you.
Rob, then Bridget.
So I have a completely different view on this. I think, you know, I live in Unit 1 when I'm not a board member. I should have to vote in my unit for my representative that represents my district. However, we are all representatives of the at-large members, and I'm perfectly okay with them hopping units or however they say it, because we're all responsible to represent them. So if, you know, there's someone on this board that's drastically hindering the representation of at-large members, we should expect a mass shift over there to get rid of them, and that should be the right of our members. Within our units, we have specific directors that we vote for. because they represent the geographical area that we live in. But with so many of our members living outside of the tribe, we're all responsible to represent them. We all have at-large members within our districts. So, yeah, I would say if one of us has not represented them adequately, we should expect that they mass enroll in our unit and get rid of us. And I think that should be the right.
Quick response to that, Rob. If we leave the language as currently drafted in the draft amendments, it would provide the ability in code to structure our code where you would have to register if we're outside every single election for a unit, and would allow could arguably allow for unit hopping because it's not written so strict. So the code could be changed to allow your scenario. If we changed the Constitution, to Tyler and yours point, to expressly disallow unit hopping, so to speak, then you lose that flexibility. So yeah, it's before we leave here today, we'll get the temperature of the majority of what they want.
I'm personally okay with leaving it to code, but I don't want that restriction in the Constitution, because then it restricts the rights of our at-large members. And like I said, we all represent them. So, I mean, if we're doing something drastic within one unit, we should expect them to gather against us, to be honest. So, but we're all representatives of them. They elect us to represent. So I think the future leaders can decide that in code based on what the direction that the members give them at the time. I want to leave it open to membership having the ability to push for the way they want it through code. I don't want it restricted in the Constitution, though.
All right, Bridget, then Kim. Bridget, we can't hear you.
No?
Still not hearing you, Bridget. All right, let's go to Kim, and I'll call on you once, Bridget, I'll call on you once Kim's done. Go ahead, Kim.
Okay, so right now, at-large has to register to vote for every election, correct?
No, right now, everyone's automatically registered, and then you have to
Got it.
pick a unit. If you're at large, once you pick a unit, you are in that unit up until the point you decide to move into one of our election units. Otherwise, my entire life, I could be in Unit 3. If I'm living in Detroit, right now, under the code, I pick Unit 3, I'm Unit 3 forever.
Okay, so every 2 years, they have to register to vote. Well, if we change it, it sounds like they will.
If you
If they
change it,
wanna
yeah.
choose
If you change it to allow picking a unit every election, then they'd have to register for a unit every 2 years, correct?
The people at large would.
Correct. If we change it,
So what kind of a
back.
price tag is that every 2 years to mail out registrations?
oh,
A lot.
It's easy, like 20 to 30 grand every time. If we're blasting out everyone at large, like 18,000 of us at large members, you're looking at, I think the last mailer that we sent out to everyone was upwards of 20 to 30,000.
So every 2 years, we'd be sending that out before the election. I mean, it's to register to vote for the elections.
I mean, hopefully we'll get more electronic means of communication with our members, the membership portal. We have things in the work as a tribe, right, to get out that message besides just paper. And maybe in the future, people could opt in to getting a mailer instead
do
of
electronic
we could do like electronic
registration.
reminders through the membership portal and stuff. But right now, as it stands, yeah, we would in that scenario mail out every off year in the fall. Like we'd mail it in 2027 in the fall. We'd mail it out, the elections commission and enrollment, to make sure that people got it in time to register for the 28 election. That scenario.
Okay, and then Rob had a point there about if somebody wasn't representing them right, he could see why they would want to get rid of them. Well, you got some people with deep pockets on this board that send out some nasty stuff about people, and they don't know what's going on here. So that side of it, I'm not good with it, because it's happened to me. You know, stuff went out there, wasn't true,
Yeah.
but they're not here to see it, so, I mean, I guess that's politics. What can you say? You know, but I just think it's gonna be a lot more expensive if we do it that way until we get something set up electronically. And I don't think we will get as many voters voting when you got, because people complain about when they have to mail in the two different ones to start with for different things.
It's a struggle that the election commission is acutely aware of to try to get more of the at-large members to vote. I think we
Yeah.
had 6% of them
Then-
vote in 2020.
Right, and if they send a
Or-
registration back and then they think that's what they were sending back when it's time to vote. And I've heard them say that before, so, you know, the discussion with the election committee.
Yeah.
All right,
Okay,
I have a point of information here.
go ahead, Rob.
So I think there's a little confusion there where it's stated that we would have to do this every 2 years. There could be an easy fix for that. The first time that we do it, we send it out with specific instructions saying that you will be registered to vote in all chairman referendum elections or secretarial elections, but you have to register in a unit. After that, we could inform the members that they have to specifically reach out to us if they want to switch their unit. So that way we're not mass mailing every 2 units. Would that make sense, Ryan?
Yes, that makes sense. Right now, the way is happening is how Kim described, though. Everyone who's not in a unit and they're at large, they get mailed out a flyer. So our current practice. is-
Right, but we could address-
talk-
we
but we
could-
could address changing that, correct? That's correct.
Yeah, we could change that in code to say the first time we do it, it's gonna be everyone's permanently registered for referendums, chairman elections, secretarial elections. You pick a unit, and if you want to change that unit, you reach out to us and we'll send you a form to do so. That way, we're not wasting a bunch of money on mass mailing. It's an easy fix.
Yeah.
Bridget?
Can you guys hear me now?
Yep.
Okay. Could we put in the Constitution when it first is implemented, that people have an opportunity to change their units right off the bat? Everyone that doesn't live in units 1 through 5 or districts or whatever they're gonna be called, because of that unit shopping prior, people are locked in that wouldn't normally be in the unit or might wanna be in a different unit without having to move there. If we could just do a one-time choice to those people that are at large, because I don't believe in the unit shopping either. We want to, in one hand, be like the state and federal government, and then we don't. You know, as far as the units, we are, whether people like it or not, the people we represent that live in our communities, there's a lot of things that we vote on that are specific to the service area too. And I'm not saying that, you know, now they still get to vote in those units, even though they don't live there, as opposed to the regular state or the federal. So,
Okay, anyone else?
that's my 2 cents.
Anyone else? So, Ryan, what's your recommendation? To me, I honestly don't really care. You know, I get elected by the entire membership, and I might be in the minority, but I don't see the issue with the entire membership electing the entire board either. But the BIA flagged this. They had some feedback. So we have your recommended response. Does anyone disagree with the recommended response? And if so, I can create some options and go through some polling. So put your hand up if you're opposed to it. Okay, go ahead, Rob.
I just want a little more clarification from Ryan. So as it stands, what would this look like moving forward? Are we leaving it to leadership to develop through code based on input from the membership?
So my recommendation is to not box the tribe in so specifically in this part of the Constitution, to leave it as is and allow that to be done through legislation. So
I'm fine with it.
I'm not recommending to add, I have language, but I'm not recommending to add it to the Constitution to make it so you're permanently registered in that unit forever. I think we should leave that more open in the Constitution and develop that through code like we do now.
And in that case, then code would stand as is unless modified by a majority of the board.
That's correct.
Okay, thanks.
Okay, does anyone feel differently? Okay, that's the direction, Ryan.
All right. Article 11 is another sovereign immunity. This is our more detailed statement of the tribe's sovereign immunity and how it extends to all its entities, etc. It's a new article, title, total rewrite. The BIA has no issues noted. Article 12, right of referendum. The BIA notes it's a new article title. It's more accurately, we changed a lot of how the referendum language works in the draft based on our current constitution. But they have a grammatical error and suggestion. Article 12, any bearing signatures of at 5%, we're missing a word. It should read of at least 5%. Their suggestion was remove the word at or add the word at least. The legal department response is the intent was to get a referendum started, you need to have at least the amount of signatures of at least 5% of the voters. So we're just saying you should add in the word at least. Grammar error.
Any issues with that, guys? Okay, no issue correcting that.
Article 13, amendments. New BIA notes, new article, new title, total rewrite. No issues noted. I will just remind the board and the membership, so in the amendment section, if we adopt this language that's currently in the draft amendments, it would remove the secretary from doing the elections, and it would be done through our own tribal election process. And that was the intent of the majority of the board when we pulled that months ago. Article 14, adoption. New article title, partial language changes and additions. The BIA noted some grammatical typo errors. Entitled to vote shall vote in such election shall be submitted to the Secretary of Interior and if approved shall become effective upon the date. We had duplicative words, become effective. So the fix, and we agree, is to delete the second instance of become effective. So the language will read, shall become effective upon the date. The rest of the sentence isn't here, but on the date of ratification by the membership. Everyone agrees?
Okay, any issue? Okay, no issue.
Moving to our bylaws. Article 1, meetings of the tribal council. In the title, there was a letter I missing in the word council. We've added in the letter I. I did tell the BIA that there are probably lots of formatting and grammar errors because it's a work in progress, but we want to make sure the membership had an opportunity to look at it. So I realized that there are grammar errors, but it was nice of them to note it for us anyway. Article 2, duties of tribal council officers, new article, title, partial language change. BIA has a question, so that's clarification. The last sentence of Article 2, Section 4 does not seem to flow with the rest of Section 4. Please clarify and or correct any missing punctuation and or add missing language. That last part of Section 4 was actually a note to ourselves to add in to the language of the legislative powers that within 5 days of them approving legislation, that they need to send it to the executive branch for signature, veto, etc. So it was a parenthetical note that is not supposed to be in that article of the bylaws. It's actually supposed to be in the legislative powers, and it is enumerated in the legislative powers. So the fix is just delete that comment, parenthetical comment out of that bylaw section.
Okay, any issue there? No issue.
Article 3, tribal records. BIA notes it's a new article, same title. About 70% of the language in their estimation changed, but they have no issues noted. That was the change to make it very clear that it's governmental records and mandates that the tribal council create within 6 months of ratification of these amendments the we're calling it sunset clause, the language in the code that mandates that the economic arms of the tribe have to turn over certain records to the government so they can be inspected, FOIA, et cetera, from our tribal membership. So that was a big change we had robust discussion on, but we wanted a path. We wanted to create that legal path so the economic arms would turn over things to the government, and then those things would be FOIA'd under the governmental FOIA ordinance.
Okay, thank you. So that concludes it. Any final questions, comments? Not so bad, no. So remind everyone what the next step is, please, Ryan.
So I'll make the changes, not really changes, mostly grammar changes. I'll make sure it's cleaned up per our discussion today and per the BIA's comments. And then I'm to send them that cleaned up version. So I'll do that tomorrow, and they will send it on to the regional office in Minnesota. The regional office will conduct their layer of the informal review. I do not know how long it'll take. The local office took a few months, so at least probably 2 or 3 months. And once I have those informal comments, I will rinse and repeat this with you all, and we'll workshop it again and see if the board is ready to finalize their draft and vote to send it to a secretarial election.
Okay, thank you again, Ryan. So that concludes that item. Let's take a 5-minute break, and then we'll jump into the last item, which is Chapter 82 Proposed Code Amendments. And we're going to go ahead and begin that last item that's on our agenda for this evening. It's titled Chapter 82 Proposed Code Amendment. So this was a board-driven item that was added. Basically, the Board of Directors are interested in codifying the changes that we've workshopped through the constitutional amendment workshops. That way, you know, if the Board of Directors passes code, we'd have a separated court. It wouldn't be fully separated because then the Board of Directors could just rescind those code changes or make different ones that conflict with them. But, you know, it could speed up this process because we could have a somewhat semi-independent court until we officially vote on it in the secretary election. So we have Chapter 82 in front of us. There are some proposed red line changes. Ryan has informed me that most of these red line changes are based on how the Board of Directors polled during those constitutional amendment workshops. That way they're in line. There's a couple examples of where it didn't follow that process, but for the most part, that's why they're red line. So Ryan, if you want to go ahead and get us started. Actually, let's do a round of introductions,
Yeah, I was
because
just
there's a
gonna say
lot
if
of
we
people
could
here
go
that people on Zoom or they're watching the stream won't know. So Tyler, why don't we start, or Kim, why don't we start with you and we'll move this way.
Kim Gravel, Unit 1.
Any Migizi Migwana Dijakash, Tyler LaPlante, Unit 5.
Austin Lowe's, Chairman of the Tribe.
Lana Stewart, Board Administrator.
Larry Barbeau, Unit 4.
Hi, everyone. Kimberly Lee, Unit 2.
Director on the board, no units for me.
Good afternoon, Sean Barovich, Unit 3.
Josh Elliott, Senior Attorney.
Jen Constantino, ICWA attorney.
Ryan Mills, General Counsel. I do have two other attorneys hiding in the back. There wasn't room up here, but we brought the whole legal team just so we could, if there's questions, and then the court as well. So, thank you.
Elizabeth D. Stesnikosh, Boating Junjapa.
Tracy Swan, the Court Administrator and Magistrate for the Tribal Court.
Carrie Byron, tribal member, Chief Appellate Justice of the Sioux Tribe Court of Appeals.
Good afternoon, Robert John Putz. I'm appointed non-attorney to the, as a justice on the appellate court.
Christina Demore, also known as Tina, appellate judge.
Okay, very good. Bridget and Rob, would the two of you like to introduce yourselves as well?
Nana Dubaneshi, Indigenous Cause, Migizi Dodam, Bawating and Dojba, Robert McCrory, Unit 1 Director. Thanks for being with us, everyone.
Good afternoon, Bridget Sorensen, Unit 3, Svet Ignis.
Okay. Those of you guys in the back want to introduce yourselves as well?
Thank you. And I'm Kirsten Seski. I'm the staff attorney.
All right, thank you. All right, I think that's everyone, isn't it? Okay, Sam, you want to introduce yourself?
Samuel Duresha, Assistant Board Administrator.
Okay, all righty, let's get started.
All right, we were in front of the board, I think it was in February, what was that, Carrie? February 17th, we had some proposed Court of Appeals code changes. At that time, we had gone through very briefly like, some of the things that we were proposing from the legal department. And the discussion was we wanted to have an opportunity for the Court of Appeals to also weigh in. This was set for that workshop. Between then and now, the board has directed the legal department to, I'll say, codify our separation. So we have a timeline that we're working internally on bringing proposed code changes to this board for a potential vote that would create the separation of powers in legislation. And so that version of the Court of Appeals code that we had previously discussed in February is not what's in front of you today. I unfortunately we were only able to finish it 2 Fridays ago, so I didn't get Ms. Byron and the rest of the court until last week, was it? The new version, based on the new direction from the board to, quote, codify our separation. So now this version does try its best to mirror the changes in the Constitution, as you said, Austin, the draft Constitution. And I do know the court did submit written comments to that effect. And I'm sure as we go through today, we'll be able to discuss each change. But these changes, for the most part, there's a few that will flag that don't, like you said, but for the most part, they're trying to take what you did in your draft amendments and incorporate them into code per your majority direction. And we'll just get into it here. The first change, changing our Court of Appeals name to Supreme Court instead of Court of Appeals.
And if I could, Ryan, I mean, this is obviously a board-driven project, and it would require a board member to put these proposed changes on a meeting agenda and for the board to vote on it. Otherwise, you know, the members will have to wait until the secretary election takes place before these changes are implemented. But I mean, this is just informational only. If the board of directors wants to codify the changes that were proposed during the constitutional amendments, this is the route to do so, but this is how this would look, basically in a nutshell.
That's correct. The other part of that is if we workshop these code changes ahead of time and we get them to a point where we think they're going to fit into that new constitution, if it gets adopted in its current form, then these can be adopted right away by the tribal council to implement the new constitution separation. So,
Okay.
but these are not set on for any kind of vote. This is just a purely workshop, purely informational right now, as you said. So in the definition section, a lot of these are what I would call clerical changes, calling them justices instead of judges to match the language in the draft constitution, calling it Supreme Court instead of a Court of Appeals. We added an associate justice instead of appellate judge. So some of these changes on the first couple sentences here, they're just clerical. Number 4 in the definition, the Chief Justice means the justice elected by the citizenship who has administrative authority over the Supreme Court. We've changed that definition because in the current draft amendments to the Constitution and this current proposed change to the code, the Chief Justice of the Appellate Court would be elected, an elected position to be in line with your proposed Constitution changes. I'll just keep going through unless someone on this side of the table or someone on this side raises their hand, because I don't know how you want to do this.
So he's going to go to each proposed change, and then at the end of it, pause for feedback. If anyone at the board level, staff level, or the appellate court level has any questions, comments, just go ahead and put your hand up. Unless like one or more board members state, hey, I'm going to place this on an agenda, I don't think it makes too much sense to go through polls, considering we just went through polls to come up with these proposed changes. But again, this is just procedural. If we were to codify these changes, just to try to beat the BIA from implementing them with the secretary election, this is how we do it. So do you have something to add based on that, though?
I just have a point of clarification that I'm looking for related to the constitutional amendments to Article 5. We thought that was going to, everything was going to start at 2, and so we didn't hear if there were any BIA comments to Article 5, because I think that if there were changes discussed, that might inform comments that we might have to these changes, because they're meant to implement what was, drafted by the Constitution. And so I'm kind of at a loss, because we thought everything started at 2.
So Article 5.
I can handle that.
Okay, go
So
ahead.
we got done with the item prior to that, ahead of schedule, so we started a little bit early. The BIA has no issues to note with Article 5. Obviously, that was one of the first things that we workshopped with that item, but you can expand on that if you could, Ryan?
I don't think I can expand on it. Their only comments were no issues noted, is what the BIA sent back.
Okay,
Yeah.
so no comments.
They had no comments, no questions, suggestions, et cetera, on that section.
Okay, thank you.
Okay, anyone else right now?
Thank you.
Yeah, she can have it.
Okay, let's move on to the next section then.
Number 6 here is a definition. This is not driven by the Constitution draft. This is just a definition we believe should be in our code. Final judgment means the last decision from the tribal court that resolves all issues in dispute and settles the parties' rights with respect to those issues. A final judgment leaves nothing to be decided except decisions on how to enforce the judgment, whether to award costs or to award attorney's fees. It's basically the Black's Law Dictionary definition of final judgment.
Okay, go ahead.
I do have, I just want to note that this is a change with regard to what the Chapter 82 currently states. It talks about a final judgment or order, and I think we have to understand the context in which these some of these draft amendments are coming. I fully respect and appreciate the board's direction related to implementing the constitutional changes for the independence of the judiciary, but we have to understand, what that means. And some of these amendments, I need to say, don't just clarify procedure, they materially reduce judicial tools. And so by defining final judgment in this way, you would otherwise reduce the authority of the Court of Appeals to hear things like writs. Now, why this is important is because it's currently a case pending before the court in which your legal department has made an argument that a writ isn't in order. We found otherwise. And so it's difficult to sit here in front of the board to have some of these discussions related to items where there's active litigation going on. And so I want to say that I don't have a problem with what Black's Law Dictionary says, but I want to say that it's not the be-all, end-all definition of what a final judgment is. And sometimes when a writ serves the purpose of being executed in violation of law, it impends on somebody's rights, and the result is somebody is evicted illegally. And so, this is talking about putting a tribal member out of your home. So if you don't want the Court of Appeals to review that, that's fine. But that's essentially what this definition does. It limits rather than clarifies.
Okay, do you have a different suggestion for how this should be worded?
I think you just need to,
So I added in the word "or order."
leave
Means
it
last decision
alone.
or order.
Final judgment or order.
Okay. Do you have any issue with adding or order, Ryan?
No, I think we have a fundamental disagreement on what a restitution is, and I want to make very clear that we're not asking the board to adopt these changes today. We're workshopping them, nor are they on an upcoming meeting. Right? These are just changes that we're proposing, and so we're not trying to relitigate any issues that are in the Court of Appeals. But I've worked in a lot of different jurisdictions, both state, federal, and tribal, and it's not very usual to see a writ of restitution as the basis for an appeal. So we're redrafting this proposed so that if a writ is executed outside of the statutory window, it is invalid, right? They have to go to the trial court and they have to get that writ reissued, or they can do a motion for reconsideration, and then that can be a final order. But a writ of restitution is not the vehicle that should be going to the Court of Appeals, and that's what we're trying to fix. Not for a current case, we're talking about for future cases when we build out our Supreme Court under a separation of powers. That is what this proposal is for. But I have no issue having order in, because that writ is still not the final order. It's an enforcement mechanism of the final order. So I have no problem putting order into this definition.
Cass, do you have something you want to say?
I do.
Come on up, join us.
Come on. Okay. I can do that. Where did I can come sit right here. So I think one thing that's important to note is the final judgment, number 6, is just under definition purposes. It's just looking at what final judgment will be defined as. Under the scope for the Court of Appeals, for the time period to appeal, when it can start, it still says written judgment or order. So order's still in there. That's not being limited. That's not being taken out by these revisions. The definition for what a judgment is just being added.
Okay. All right, let's move on to the next proposed change.
Number Number 7, Supreme Court means the court established for the tribe in this chapter.
Okay, it seems pretty basic. Any questions, comments there? Okay, let's move on to the next proposed change.
Number 6, we're changing tribal court to trial court to mirror how we're setting up in the draft constitution. Trial court means the trial level court of the Sault Ste. Marie Chippewa Tribal Court.
Okay, any questions or comments here? Okay, let's move on to the next proposed change.
Same thing with the next two. The next two changes, they're mostly just clerical. The trial judge. Sorry, that was this one should not. This was a global change, and I apologize. The tribal judge means the trial level chief judge and associate judges and other judges appointed pursuant to Chapter 80 of the Tribal Code. That's just a clerical definition change.
Okay, any questions, comments there? Okay, hearing none, we can move on.
Number 9, we're just striking that. It's not. We already have that up above.
Okay, any questions, comments here?
So this one, 82.103 is going to be, if we change this in code or if we change this in the draft constitution amendments, this is going to be a substantial change for how the court is currently made up. Currently, we have 5 judges on our Court of Appeals. The current draft of the Constitution sets that down to 3. So these changes now say the composition of the Supreme Court is 3 justices who shall sit on the Supreme Court and hear all cases unless disqualified pursuant to 82-107. There shall be 1 Chief Justice and 2 Associate Justices and any other Associate Justice or substitute justices as authorized by law. Any number of justices may be appointed as reserve justices who shall be available to serve on the Supreme Court to hear a particular appeal for which an appellant judge is disqualified or otherwise unable to sit. The big takeaway here is you're dropping it from 5 to 3.
Okay, any
Which-
questions or comments here?
No, I think there was a resolution to that effect addressing the composition of the court in 2024. And so that's consistent with what my understanding was as well.
Okay. Yeah, we workshopped this. At the end of it, we had a series of polls, but right now, leadership favors the composition of the Supreme Court to be made up of 3 justices. One would be a Chief Justice, and then 2 would be the Associate Justices. So I believe Chief is elected, then the Associates are appointed. Is that correct, Ryan?
That's correct. We'll get to that change next here.
To be in a appointment process, yeah, through nomination and all that.
Yeah, in the Constitution draft and in this code, it would be the chair of the tribe would nominate the associate justices, and then the board would confirm them or appoint them. They're all appointments now. We get their resumes and they put in for this, and then the board interviews them, right, and then they appoint them. This would change it to, you see number 2 here, qualifications of Chief Justice. This mirrors the Constitution language. Chief Justice shall be a voting age citizen of the tribe and a licensed attorney in good standing with the State Bar Association, except where no qualified tribal citizen seeks such office. An attorney in good standing may be appointed.
Any discussion here?
Yeah, just to flag it, it's later down, but this position is elected, like you said, Austin. So.
Okay. Okay, I don't see any hands up, so we can keep going.
Number 3, qualifications of associate justices. Associate justices shall be of voting age. At least 1 of the associate justices shall be a citizen of the tribe. All associate justices shall be Native American, and at least 1 associate justice shall be an attorney. Where no qualified tribal citizens seek such office, an attorney in good standing may be appointed to be an associate justice to fill any vacancies. So the default is a Sioux tribe citizen, if possible. If not, at least try to populate those 2 associate positions with all Native American. If there are no tribal citizens that put in for that position, then it would be any attorney, whether they're tribal or not, could be appointed. So what that effectively does.
Okay, any discussion? Judge Byron?
I'm just wondering if this this was workshopped in the, is this what's in the Constitution as well?
Yeah.
Okay. And I know that you had discussions about whether or not those people needed to be licensed attorneys. I would just, and I think that we voiced in our memo related to just the qualifications of judges at the appellate level or now at the Supreme Court level. Largely what's happening is you're hearing and deciding on issues of law. And it makes it difficult. Some of these legal principles are nuanced and difficult to understand. And I have a fear that, so you have the Chief Justice who is required to be a citizen and is also required to be law trained. And then you have 2 associate justices who could just be tribal members. Hopefully they have law degrees or some level. Just one of the 2?
Yeah, one has to be an attorney, one can be not an attorney,
Okay,
as long as they're Native American.
So there's a fallback if you can't occupy the court with Sioux
Okay.
Tribe members who are all law school educated.
okay. So the other, I mean, I guess where my concern is, and this just comes from the experience. I mean, I've sat on the Court of Appeals since 2014, and I've sat with any number of combinations of attorneys, non-attorneys, and it's the workload and I guess the explaining and the education that goes along with some of these principles of law and trying to focus folks to concentrate just on, the issues of law and realize that there's a separation between the Court of Appeals and what we're allowed to hear and the lower court, which is the finder of fact. And so at the appellate court or the Supreme Court level, I just have a concern that we have, that we're going to create a situation where, the 2 attorneys are going to gang up on the non-attorney, number one. Understanding that, they have the understanding of the law. And so I just wonder what is the thought process behind not having them all be attorneys so that you can have, or even working in the elder that, we have 2 elder members right now who add so much value to the panel that we have. They inform of culture, tradition, and I just see this losing some of that, which is discouraging.
Okay, Tyler, would you like to add something?
Without going into too much detail as requested about the previous position, specifically, my concern is that this court will be hearing constitutional-related matters. Now, I would be fine with going with all attorneys if they were all Sioux Tribe citizens, but I don't think anybody outside of this nation should be making decisions for this nation ever again. That has been put clearly to us with what has recently happened, and I will not expand on that any further than I have to. However, the United States would not seat somebody on the Supreme Court to overhear constitutional rulings that was not a citizen of the United States. And therefore, neither should our tribe. Right now, at the very least, while it's not perfect, the entire board of directors, none of us has a law degree, yet we make decisions based on the Constitution. And we're all elected citizens of this tribe to represent this tribe. I understand your concern about the law-specific appeals, but I too have a concern specifically about the protection of our Constitution, especially creating a new one, and the interpretation of somebody external from this tribe or a non-tribal citizen making a decision for our tribal nation that could influence lawsuits, court decisions, and our proceedings moving forward for generation to come. So I think the one person sitting in there, aside from the Supreme or the Chief Justice, as a Sioux Tribe citizen sitting in there, should speak more than enough for our people, for constitutional matters. Now, if we were to separate a constitutional court from the Supreme Court strictly for appeals purposes, that would be a totally different discussion. It would change the discussion we have with the almost approved or very limited error amendments that we have in place. But there is a serious concern about interpretation of our Constitution by a Sioux Tribe citizen, either with a law degree or without a law degree, versus somebody external from here as a tribal citizen, versus a non-tribal person at all. There are serious concerns, and I'm unwilling to backtrack on that, especially after recent discoveries of what was being said publicly and things that it put at risk for us as a tribe. And we're not talking about a few dollars here. We're talking about multi-millions of dollars and potentially infrastructure devastation. So that is the concern that we had. That's where the discussion was. That's why that was voted on the way it was or polled on the way it was. I would be happy to move my stance if we just put it to all Sioux Tribe citizens. I don't think all court members have to be full-time. I don't think they all have to be here if they're making decisions. We live in a remote world where people can work remotely, especially on constitutional related decisions. I'd be happy to move my opinion on that. However, my opinion's not going to shift on the interpretation of the Constitution by a non-Sioux Tribe citizen, not after our recent findings.
Okay, anyone else? Go ahead, Carrie.
So, thank you for that, helping me understand where you're coming from. I'm wondering then, because you have qualifications or a requirement here that you be an attorney in good standing. That means something. That means you have a law degree. You are a member of the State Bar Association. You basically have passed a litmus test, so to speak, in order to sit on the court. Is there something that can be done to put in qualifications for the tribal member that you would otherwise appoint? And so because I think that there's a big difference between an Elizabeth Dietz and my dad. And, and so I just wonder if there are some qualifications that we could add for the layperson, because I think, having a layperson and them not having a law degree isn't the issue. And if they have to be all tribal members, that's a decision for this board that I'm not questioning. But I am concerned with the integrity of the court and their ability to decide on these issues of constitutional import. So there should be some qualifications other than them just being a tribal member.
So I can speak about that. So I'm not saying that I'm going to be in this role if we successfully have a separation, but if I am, one of the things that I'm going to be consistent about is I'm not going to nominate anyone to that court without a law degree. So I don't think that being an elder is exclusive to not having an elder or a law degree. I think that you can be an educated tribal member, have a law degree, you can be 60 years old and can be just as respected in the elder community as someone without a law degree. Same thing with culture. Like I always use like Marty Reinhardt as a great example. I mean, he has a PhD, super well educated. I would never once diminish his status as an elder or someone who's culturally competent due to his education. I wouldn't do that for someone who's law school educated as well. So that's just my position, my thoughts on it. So any other discussion on this? Okay, yep, go ahead.
Turn it on.
Whoops, oh, there we go, it's on, okay. Yeah, Justice Butts, and I might have misspoke earlier, I'm a non-tribal member appointed to the justice. My question is, when I was interviewed, it was by a judicial committee of some sort. Are you still going to do that, and then that goes to you as the chair, and then, or is it just you?
So the way the Supreme Court will work is the Chief Justice will get elected, and then the Associate Justices will get nominated by myself and then get confirmed through the Board of Directors, kind of like how U.S. Supreme Court Justices go through that process. So there wouldn't be like a board or whatever phrase you use to describe it, but it would go through my office or whoever occupies my office.
Okay.
And Judge Butts, sorry, I don't mean to interrupt you. We haven't fleshed it out yet, but one of the things that we have flagged for the board is one of the potential codes that we want to maybe create for the tribe when they separate is an appointments code that lays out how the OGMA, as we call it, the chair, would solicit appointments for different committees or different authorities or the court. But that's not been fleshed out. Yeah, but that is something that we're going to talk about when we implement the separation. It's something that we're going to at least present to the board to see if they want to do it that way. Otherwise, it would just be as Austin described it. Yeah.
Okay. All right, any further discussion on this proposed change? Yeah, go ahead.
So I just, we haven't gotten there yet but it is the qualifications section, so I'm assuming we're talking about the whole thing. And 5B, related to serving in any capacity for any tribe, state, or United States of America, excluding appointments to committees formed for the public good. First, I don't know who will determine for the public good. But I do want to say that outside professional and civic service is the norm, not the risk. Across tribal, state, federal courts, judges routinely serve on boards, practice law in other contexts, and advise governments with conflicts that are managed through recusal. Blanket prohibitions don't increase ethics, they reduce the pool of qualified jurists. And so I will just say to you that if this provision is enacted, not necessarily that you want me in this position, but I will not be able to serve because I also serve as general counsel for another tribe in Michigan. So this disqualifies me as a judge.
Well, let me explore that for a second. So what's your opinion on that, Ryan? Because we obviously don't want to disqualify Judge Byron. We don't want to make it harder to sit on our tribal government, but at the same time, you can't swear an oath to like a city government or anything like that. But there's a difference that, okay, I'm gainfully employed in a different position, and I'm also serving part-time on an appellate court. I mean, I don't see a massive conflict or any for that matter.
No, I agree with Judge Byron. I think so. Originally, this was one of the very early workshops. The language was just state or United States, and then I do not remember all the conversations, but around the board table, it got decided to insert tribe in, I believe in part because the 2008 draft of the Constitution had tribe, and it was one of those ones that we were, at that point in time, trying to stick to the intent of 2008. But personally, no, I think I agree that this does limit it. We had those discussions.
Do you think with the current language, it limits her ability to serve on the appellate court?
Yeah, no,
Okay.
I 100% agree.
Okay.
I wish she would not be able to serve as the general counsel of that other tribe and as our chief
Well,
justice.
before we vote on this, to send it out, flag this so we can have that conversation, because Carrie, we don't want to limit you. We don't. I mean, I have the utmost respect for you. You serve on that, the court you have for the last 12 years, so we don't want to make it so certain people can't apply. We're not trying to do that.
It would also make it difficult, I don't want to pick on Carrie's situation, but like other attorneys on the board, they might have different capacities for other tribes. They might sit on multiple tribal court of appeals. We did have this discussion months and months ago, and that's not the way it played out. I'm happy to revisit it and re-poll the board, because this is constitutional draft language, so we need to revisit it in that.
Let's circle back when the time's right. Okay.
And if I can, I just want to add, that was one of the main points I wanted to make, because I'm familiar with several judges, highly qualified and respected as national experts that serve 2 or 3 tribes. They include Matt Fletcher, who's serving you now, Melissa Pope, also from the Little River Band, and another name you are familiar with, I'm sure, is Michael Petoskey. He's a trial court judge in 2 different tribes. So that to me was like, when I saw that, I said, that's shocking. And if I interpreted it wrong, I guess I may have, but that's the way I read it, was, we'd lose pretty much our whole Court of Appeals as it now sits.
I can't remember how polling went that day, but rest assured we'll fix it.
Okay.
Go ahead.
The other, so I also am a resident of Watersmeet Township in Watersmeet, Michigan, and so I serve on the Planning Commission for Watersmeet Township. And so I noticed that this doesn't say local, and so I'm assuming that that doesn't disqualify me, but I think that we need to do, maybe when you revisit it, I would suggest that maybe we, that you address the for the public good language too, because I think that judges, like Judge Butt said, throughout Indian country serve as general counsel, educators, bar leaders, trustees, and advisors. And I think that the integrity that you're trying to preserve and the oath to the Constitution and those things are served by ethics and recusal, not elimination of experienced jurists. And I think that if we believe our courts can't manage those conflicts responsibly, then the issue is the ethics framework, not necessarily the judges who serve. And so I just really want to make sure that we are, that we're looking at some of that language, because once it's in the Constitution, it's there. And so to codify it here also is problematic.
Okay, yep. We'll circle back on it.
Yeah, I'll just, for Carrie and everyone's context, at one time, one of the drafts that we went through just had A and C. B was inserted back in. I took it out, we put it back in. We can take it out again if the majority wants to. Yeah, I think it can be, honestly, I think it can be entirely stricken from it. The main purpose of this section is that we don't want people working in different branches or different parts of the government if it's not a separated power. And we don't want to create a conflict of interest. Those are the two big things that we're trying to cover. So I think we could probably just strike out B entirely. And it was at one time stricken out and then put back in, so.
Okay, let's circle back on it. Okay, let's move on.
I had a question also regarding the language that, does it say attorney, attorney licensed, or attorney equivalent? I wasn't quite sure how you were wording that.
I honestly can't remember off the top of my head either. Ryan, can you remember? Is it licensed and good
Licensed.
standing with the state bar?
Licensed attorney in good standing in any state bar. Doesn't have to be Michigan, it can be anywhere.
Did it say our equivalent, our tribal member, or?
No, and right now it does not.
Okay, because I would like to know if an elder who is a tribal member of long standing, too long maybe. Some people think that's my Indian name. For many years, and from a family that lived here forever, back to years and thousands of years ago. And I'm sure that you know most of the family. I just think that there's a difference between a person who goes to law school and gets a degree and maybe doesn't really have much practice, and myself, having worked pro se for many insurance companies, because the insurance companies themselves as an entity were allowed to be sued. And whether it was morality claims, automobile accidents, whatever, I had an outstanding record of pro se judgments for our insureds. And I was allowed to just go down to the courthouse and just do that myself without any degree. And also, I sued the governor of the state of Illinois, the second most powerful state in the whole United States, for to have him close the wing of a museum in Illinois that held 350 Native Americans, including a mother who died in childbirth, and people that were around the perimeter of this were allowed to throw popcorn at the grave sites and at this little baby who was inside the mother who died in childbirth in the skeletal remains. And I told them that they had to close that because those were our people. And they said, well, we don't know who they belong to. So I went out and got some blank adoption papers and had those signed up, and we adopted them all. And then they said, no, we're still not going to close it because, this belongs to the archaeological group and stuff like that. So I said, okay. So I called the Sun-Times and said, meet me at the graveyard up on the hill tomorrow behind this one place. And I said, we're going to be exhuming the graves of the great-grandparents of the governor of the state of Illinois. So they met us, and we had Floyd Westerman and people like that there. It's inventive, creative way of, not having a law degree. If I had spent that time in school, I might never have known these people. And they said, what are you doing? And I said, I'm an archaeologic Indian person, and I'm going to be studying these people. And they said, you can't do that. And I said, you do it. So that's just part of my background, and I also am one of the few pipe carriers that is female. And I not only make pipes, I went to Pipestone and secured for this tribe a dig and brought some of our youngsters out there, and we dug and mined some pipestone and had, as the curator of the art museum and the person who established it was Bonnie, with her permission, and built it into something that showed people we're not just a casino, we're also cultured people. And they went out there and they got their stuff, and I showed them with one of the people that came with us from Pipestone how to go about making the pipes. And I've also been one of the few women that was asked by the Lakota people to be one of the women that was allowed to participate in the ceremonies of the Sundance, which was a great honor. So, there's more to us as people than a law degree. There's also the degree that comes from us having the background that we do and the sacredness of the ground. We are some of the few tribes that actually live in the place where we were put by the Creator. And I'm still out and active, and I helped Bonnie to also set up language. And the reason for that is I have a daughter who works in the Bureau of Indian Affairs Land Management and manages 350 million square miles of Indian land. And she said, Mother, did you know if you don't have a spoken language that you're not registered as a tribe? And I said, what? And it's in the Constitution of the United States that, certain things go on and then they change things like you do. And they had put in there that to be a registered tribe, one of the 4 things that you have to have is a spoken language. And so Bonnie immediately said, she went to Bernard, and Bernard said, we have to have a spoken language. So they quickly rounded up the speakers and got a language program going. And not only the language program, but we also had the cultural program and the art gallery, of course, and also from that sprang the traditional medicine people that we had. So I would say that you should maybe add or an equivalent thereof. I would be very appreciative of that, because I don't want to not participate in this, because I think the law is something that we have always had. We always were a people that had a certain way of life that respected not only ourselves, but the whole nature that we live in, the whole people that we are. And so in order to keep that, we have to have elders that know a thing or two. I might know a thing or 3 even. Thank you very much. Miigwech.
Thank you. Appreciate you sharing that. So, Ryan, can we move on to the next proposed change, please?
Are you going to term, or are you, can we do?
Did we skip
6?
ahead? So I just want to put on the record, so to speak, that we did, as in the Constitution, if you have a felony, you can't serve as a justice. Number 6 here, I'll just do it real quick. Number 6 just says basically that justices, if you enact this code, the justices have to be in compliance with the qualifications. If they're not, they have 30 days to do so. And if they cannot, for some reason, get in compliance with the code, then their appointment will be rescinded. We'll pause for a second, yeah.
Yeah. I just have a question
ahead.
about the current makeup of the Court of Appeals. By virtue of 2 attorneys in good standing appointed rather than tribal members, or that they won't be able to rectify their non-Indian status within that 30 days. So I think that, I mean, that immediately eliminates 2 of the 3 justices that we have. We have a remaining 2 that are tribal members, but one is not an attorney, or both of them are not attorneys. And so I think that this 30-day requirement, rather than maybe a suggestion that I would have, is to allow for the current makeup to remain until the Constitution is in effect.
That's
Or-
even if a board member wants to put this on an agenda and pass
Right,
it.
right. I just want everybody to realize that that 30 days is, with this in there, is going to disrupt the business of the Court of Appeals very quickly. 30 days is not a long time.
And I'm not married to any, so we, 30 days, it could be a year, it could be 6 months, it can be anywhere in between. I don't, you all might surprise me maybe and put it on for a meeting, but I don't anticipate that the board is gonna vote on this until we decide what we're doing with the constitutional amendments. But I'm certainly not opposed to some different time frame.
Okay.
I mean, we give many positions that are attorney positions like 6 months to transfer your law license. You can do 6 months to get in compliance with this code. It can be any number.
Let's
I don't want to
flag
get hung
this.
up on that.
Let's flag this, Ryan.
Yep.
And if we're in a position where it's looking like there's gonna be a vote on this, we're gonna need to workshop some of these issues.
Okay.
The compensation language of number 7, same as the constitutional draft, gives the power of the board of directors to establish a level of compensation, but not decrease that level of compensation while those justices are in their term of their appointment. It's almost a verbatim copy and paste from the constitutional draft. All right, let's get to term here. 82-104 term. Man, I should have read, these red lines are hard for me to read.
I think there's a typo. Says 6th term to expire in 2028. I think you meant 6-year term. There was a over deletion.
Yeah, so we have it, so we try to stagger it just like with the Constitution draft. So the Chief Justice shall serve 6-year terms to expire in, not 2028, whatever, 6 years. 2032. One associate justice shall serve a 4-year term and expire in 2030. One associate justice for a, yeah. I'll have to double check this one, Austin, I apologize. I'll see if these terms match up with the Constitution. But the point is to try to stagger them out so they're not all being turned
Right.
at the same time, right?
So you
Well,
don't have the potential
I'm just
to
gonna
have
make a note, we'll
100%
clean this
turnover.
up, clean this up, make sure the timelines are the same as the Constitution. But I believe it was 6, 6, and 4.
Okay.
So like the Chief Justice is 6, one associate is 6, and one associate is 4. It was something like that in the Constitution. I'll make sure I marry this up with
Yeah,
that.
if you could refer back to it, we'd appreciate it.
Yeah.
Right now, if we adopted this year, which I don't anticipate, so this is fluid, the first election for the Chief Justice would occur in 2028. But we'll change that if the Constitution passes, or if this passes without the Constitution passing, then we'll modify that accordingly to whenever this passes. It'll take place at the next general election whenever this code is enacted, if it gets enacted.
So the general election after the enactment of the code.
Yeah,
Okay.
correct.
Okay, we can keep moving on to the next proposed change then.
82-105, Chief Justice. Chief Justice shall be responsible for the administration of the Supreme Court and shall have such duties as are specified in this chapter and as may be conferred by a provision of another chapter of the Tribal Code. Chief Justice shall have the authority to create and present an annual budget request to the Board of Directors. The Chief Justice shall have the power to propose new court programs, policy, and procedures subject to approval of the Board of Directors. The Chief Justice shall not be able to enter into any MOU, agreement, contract, or similar with any entity inside or outside the tribe without approval of the Board of Directors. That sentence only works in our current structure. That does not work in a separated structure. Because if they're their own branch, they can, of course, enter into their own contracts. So that language, if we separate, doesn't have the same effect. We'll have to change it. That language is trying to incorporate the separation into our currently existing structure. If there's a vacancy of the Chief Justice, the most senior Associate Justice shall be the interim Chief Justice.
Disrupts the entire operation of the court. And so I think we need to be careful here related to, limiting authority is, if you're truly looking for independence.
Yeah, and I mean, that's the irony of what we're doing right now. So, I mean, we're talking about codifying the court so it can be semi-independent, and I use that word purposely because, I mean, you could codify the independence of the court, but then the next day the Board of Directors could rescind whatever code changes that they made, and then you're back to where you were before.
Yeah.
And I mean, like, right now, the Board of Directors is the one branch of government. It's not a legislative branch, so it's also the executive and the judicial branch, through creating the code that created the court. So I understand, the concern right now, but right now, until you have a separation, it's the best we have. Tracy?
What I want to say is for the last 15, 16 years, what the court has done is created court rules. We have made the rules to work within the court for procedure. And what we do is we send them to the appellate court for their review first, their comments, then we revise them, and then we put them out to public comment. Wait 30 days for public comment, and then we adopt those court rules. Because there are days or something going on that we need to have something in place to follow, or for the attorneys to be able to follow procedure to refer back to.
Okay, I appreciate it.
And just to give some context where this language came from, in our current draft constitutional amendments, the legislature has the power to create by law like a civil procedure code, a criminal procedure code, but the court has the power to propose changes to that code, but they retain the power, or have the power, however you want to word it, to create their court rules. And so we purposely didn't put the term rules in here to mirror the Constitution. Because right now the draft is set up where the court can create their rules, but the legislature has the power to create a law that defines what if they want, like we do now. We have a civil procedure law, we have a criminal procedure law. The legislature in the current draft has that power to continue to do that, but not to create court rules. Those are two different things. I don't want to, I understand what the court's saying, but I want to make sure we're on the same page on what the Constitution says, and that's why this language has that, because they had the power to create their court rules, and we didn't want to change anything in the code. We still want them to have the power to create the court rules. But if our Constitution draft passes, they don't have the power to create whatever civil procedure they want. That is with the legislature right now in the draft amendment of the Constitution.
And I totally agree with that. I think that if you look to federal law or state law, there are criminal procedures laws that guarantee basic rights. But when, for instance, the law is under Chapter 82, you have the right to appeal in certain circumstances. But this doesn't necessarily tell you, what the form of that appeal is, the page numbers of the briefs, all of those things, and that's what court rules do. So I certainly, and I don't think anybody on the Court of Appeals wants to step into the shoes of the legislature to determine what the civil procedure or the criminal procedure of the tribe is. But I do think that if in the current draft constitution, which we're getting a little bit off subject because I misread this provision, so I apologize, but if the board has the ability to approve those rules, which as it currently is written, I believe they do.
I'll double check, but the
I-
intent is just the procedural law, not the code. I think I emailed Tracy about it. I'll double check on the language,
Okay.
but that's not the intent. So if it is, I'll change it. Yeah.
Okay, so that's helpful, but I also think that if we have to carry out the business of the court through MOUs, agreements, contracts, like, regularly, the court needs to order transcripts. Necessarily, those transcripts might come with some sort of, service agreement or something along those lines. If the court can't sign those things and it has to all come to the board, that's gonna be very disruptive. So, maybe add something in here related to, out of the normal course. I understand you have your contracting procedure or policy, but I would think that if you were gonna enact that, the policies of the tribe wouldn't necessarily apply to the court, and its general operation.
Right, yeah, right now they would, because the court is part of the government. In a separation, I would agree.
We're still gonna
right,
be part of the
they
government.
wouldn't.
We'll just be the judicial
yeah,
branch.
But you'll be your own branch, excuse me. Yeah, you'd be your own separate branch, but right now you're not, right? We're trying to sort of create that through code potentially. And so the stuff like that doesn't have to go to the board for any other department and under our policies and procedures for purchasing, et cetera. And so this is not intended to disrupt that. So this would be like, I don't know, you're getting an agreement for, you're creating a public defender's office or something, and you're gonna contract with a couple attorneys to populate the public defender's office. It's gonna be through the court budget. That would come to the board. If you're doing a purchase order for supplies or for transcripts, that shouldn't and doesn't currently come to the board, and this
Sure.
is not meant to change that dynamic.
So not switching from my role as Chief Justice of the Appellate Court, but just giving you some general context. The tribe where I work, they have to submit contracts that include waivers of the tribe's sovereign immunity to the board. Otherwise, they have the authority to contract. And so I think that if you limit it in a way that would allow the court to operate, but ensure that check is there, that might be one way to resolve this issue. Because as long as the contract itself doesn't include any sort of waiver of immunity, then I think that the business of the court would just remain the business of the court. But where it implicates additional issues for the tribe as a whole, it should come before the board.
And that's how it works now. We have other entities that have the power to contract and create MOUs, et cetera. But it's all subject to the policies we built in. So if there's a waiver, it has to go to the board or the KGA or the Enterprise Authority. If it's above that executive signature authority, then it has to go to the board. Otherwise, yeah, a lot of the contracts they currently don't have to see the board or the governing authorities table, so to speak, but they still have language in their codes that give them that power to contract, subject to board approval, but we still have those caveats. They're not all built into code, but they're in our policies and procedures, or else you'd be inundated with contracts every single board meeting, which you're not, and we operate that way currently. Yeah.
Okay.
And I think, Ryan, just this was flagged because of, I think, the email and the email you sent to us about the contracts, like with the MSU Law Clinic. And in our day-to-day work at the court, there are days where we have to enter into agreement immediately with Smart Start. We have to get a tether on a person. There's days we have to switch drug screening companies because our contract ran out, so we're entering into a new contract because we got a better price, or the window detection period is larger, things like that. But that has happened all of the time, and so that's kind of when you sent the email, it kind of flagged that for us, like, okay, we've been doing this all the time, and to stop that process would slow the
Yeah,
business
the
of the
only one of those that
courts.
you mentioned that I think falls under our current policy is possibly that one with the ILPC. Otherwise, the other ones wouldn't fall under.
Okay, are we good on this topic? Okay, let's move on then.
82106, clerk. There shall be a clerk for the Supreme Court. The clerk shall not be an employee of the trial court and shall not have access to any non-public documents of the trial court except where sent through the lower court record in any pending appeal. So currently, in the draft constitutional amendments and all the workshops we've done and the financial planning, it's envisioned that there will be a clerk for the trial court and a clerk for the Supreme Court, and they aren't the same, and they aren't the same person. They're two different positions, and that's the intent of the Constitution and everything we've been drafting in that realm. So that's just translated over here into code. It doesn't have to happen right away if this happens before a Constitution, but when the Constitution happens, we're going to have to make that change where the clerk of the Supreme Court is separate from the clerk of the trial court, and the way it's currently in its current form.
Okay, any questions, comments? Looks like you're thinking, Carrie.
Yeah, I'm thinking, and I appreciate that, but I just want to say that I think that the court administrator magistrate who oversees that clerk, I guess I don't understand clerk, because I know that I know Tracy serves in that role now. She's not the court clerk. She's the court administrator / magistrate. And so what I'm trying to understand is like how that works in practice. And then just from a functional standpoint, that seems awful expensive and redundant, especially when, I mean, I know Tracy's being asked to cross-train people and make sure that they can fill multiple positions, and so here we're gonna separate out, that the clerk can't be an employee of the trial court. What happens if we have an appeal that gets docketed and there's like nobody in that position? Who fills that role? And so I just wanna caution, I mean, we aren't a state court. We're not Chippewa County. We're not, other places where there are multiple people who fill, those roles. We run a small, tight, efficient operation, and, I just don't know how this translates from paper to practice, really, in Indian country. Just thinking about the courts that I practiced before and the courts that I have been, involved in Indian country, the clerk of the Court of Appeals or the magistrate or the tribal court administrator normally sits in the same position for the same level of courts. So I just don't know how practical it is. And I don't necessarily know why it's necessary. But maybe there are things that I don't know.
So Ryan, is this something that was supported by the Constitutional Committee?
Yeah, that draft had a clerk. It gave the trial court a clerk and it gave the Supreme Court a clerk.
That's your answer.
So it's left over from the 2008?
Most of the changes are for the 2008 draft. We pulled some of the items that just aren't workable in 2026, and that's not one of them. I mean, instead of one employee, you have two. You know what I mean? You can make the argument that it might be less efficient, but I mean, we can make it work, unless the board chooses otherwise. But I had the same argument when we were workshopping the executive branch and how there's a requirement to create X amount of positions, and myself and Aaron are the only people up here that have ever sat in that office and saying, it's just not needed, you guys. If you guys want to inflate the cost of this thing
Right.
to create sticker shock, you totally can, but it's not needed.
Right.
And it might be one of those situations, I don't know, but it was supported by the Constitutional Committee.
I think I can't speak for the 2008 committee, but from the members I have spoken to, I think part of the reasoning was once we have a separated government, we may see an influx in cases, both at the trial level and at the Supreme Court level. I don't know how it's played out at the tribe you work for, Carrie, if it played out the same way. But I've seen other tribes that when they initially separate, those first few years, they're inundated with a lot of, people are testing the waters, right, to see the limits of what the Constitution and the court, et cetera. And I believe the advice from those attorneys that drafted the 2008 version was you're going to have so much work that it's not going to be able to be handled unless you have two positions. Whether that's true or not, I don't know, but I believe that was the original intent.
Yeah, I appreciate that. I think that the separation actually probably will cause more operational inefficiencies than it would resolve. I think that because of the institutional knowledge that, that sits in that office, I would say if another clerk is necessary, then let the court determine that because of the increased caseload. I fully expect that probably will happen here because there will be individuals who want to test the waters, so to speak. But I think that separating that out and putting that in the hands of someone who doesn't have any institutional knowledge and making it a new position probably hinders that process more than it helps it. So I mean, that's one of those practical things that maybe you can hash out if it ever comes to fruition, but I would suggest that you just strike it. The court staff, I mean, it should just say, there shall be a clerk for the Supreme Court, period. And however that happens is managed operationally within the court.
I mean, potentially they could do that, but then I'm also going to hear out of my other ear why you're changing what the Constitutional Committee recommended. So it goes both ways. If we hire someone, obviously we want to onboard them as quickly as possible to build up that institutional knowledge, which is the case anytime you have someone retire, resign, move on, but we'll just have to do the best we can with that.
Yeah,
Okay, go ahead.
Just for context, if it was to happen today, if we were hiring a clerk today for the appellate court, we've averaged one appeal a year, excluding election cycle complaints. It's been the change of judges and the change of prosecutors. That's this year. I think we've had six appeals in 14 months. That has not been the case ever in this court. I do believe that once the Constitution changes, we are going to see an influx, which
Absolutely.
would probably require its own little corner. But I just wanted to put into context that having a separate clerk today wouldn't be cost effective. It wouldn't make sense for somebody to sit there and do nothing for half of a year.
I hear you, yep. All right, you ready to move on, Ryan?
Okay. 82-107, disqualification of justices. I'll just scroll down to the new language. A lot of this is in our current code. We have number 5 here, engaged in prohibited ex parte communication as enumerated in 82-126 of the code. 82-126 further defines that. This is not, I just want to make sure we're clear, this is not in reaction to anything that's happening in our tribe or our court. This is language that we've pulled from other separated tribal governments, and we just think it's good to have in there as it'd probably be standard practice anyway, where we could recuse a judge if we found out they had ex parte communication. We just think it's helpful to have it expressly enumerated in code, and other jurisdictions to have it.
Where?
Or 5.
No, I was looking at 82-126,
I
trying
think
to
the numbers
find-
are slightly
Oh, yeah.
messed up
Yeah, they
because
are.
they switch up, so it would switch to 82-128.
128?
Ex parte.
Thank you.
Yep.
Thank you.
Okay, any more questions, comments on this?
Yeah, I mean, we directly commented on this related to the ex parte communications in the memo. I think that as written, if this hasn't been changed from the last, then as currently written, it prohibits judges and staff from communicating with a party or counsel about issues, of facts or issues of law in a pending case without notice or opportunities for all parties to participate. Improper ex parte communication includes discussing merits and receiving non-record facts or providing strategic guidance that could influence communication. We need to be very clear that ex parte communication isn't communications that are administrative or procedural or enforcement related. And so I think that it's important that we understand that the court has a job to do, and so do the departments that practice, or the people that come before the court. And so if the court has to reach out related to administrative or procedural enforcement of things, that's not an ex parte communication. That's efficient administration of the court. And so I appreciate you saying that there are things that this isn't in relation to perceived ex parte communication, but I also find the timing of it being instituted in this document suspect. And so I just really, I want to be careful here, because there are, ethical standards that we have to adhere to as judges and as attorneys. And, my reputation means everything to me. I wouldn't cross that line. And I don't think anyone sitting on our court would. And so I don't know that this is necessarily needed. We're bound by the Michigan rules of professional conduct. Ex parte communication is not allowed, period. I mean, that's just, so I would ask that it be stricken. I don't think it's necessary.
No, and those things that were just enumerated, I don't see how those would be issues of fact. So it's prohibiting connection with issues of fact. If it's administrative in nature, then it's not talking about issues of fact, so it's not covered by this language. I will double down that we should have this in our code, maybe not currently, we're confined, but in the future, I think it just better protects the ability of parties to recuse a judge if there is prohibited ex parte communication to be found. I don't see a downside of having it in the code, and
We talking about the upper court talking to the lower court about facts of a case?
or a judge talking to a party, or a judge talking to a board member who is engaged in litigation with the court, or any of those, if they're talking about the facts of the case. I think it's important to have in the code, and I don't think those other things would be encompassed in this definition, because those are not talking about issues of facts, those are talking about administrative procedure.
Cass, did you have something to add? I saw your mic go
Yes,
green.
I do. There is not concern with the current bench, as Byron states, but they will not forever be the bench. This code will forever stand until it's further revised, so having those protections in there, so if there is a bad seed that gets on the bench, or someone does talk further, and as the code states right now, there's the possibility that there's going to be one justice who is not a licensed attorney. They are not held to the same ethical standards per their bar license for ex parte communication. So if you have a license as an attorney, you can't have those ex parte communications for your license purposes, and there's that protection there. If you don't have that license, there's not that protection there. So having this in our code just protects further for the future, and I think it's far more beneficial.
Okay, Carrie?
I think that having it in the code, even though it's something that's understood within the practice of law, I don't discount what Ms. Ivanen said related to, non-licensed attorneys, but that's just another reason why licensed attorneys, or the equivalent of, should sit on the court. But I think that, by putting it in here, you're calling it into question, you're calling it out. And so it's going to be one of those things that it'll become a red herring, it'll be a distraction, because it will have to be deciding whether or not something is ex parte communication because somebody doesn't like your ruling, because somebody doesn't like what you said, or somebody questions what you said about, so-and-so. How do we prove that there's ex parte communication? So we're going to be having like recusal, there'll be a motion to recuse that will come, and then there will be a decision related to that recusal. That's civil procedure. So then, a lot of times, a motion to recusal comes before the same judge that is asking to be recused. This is the appellate court. This is the court of last resort. So if the judge says there weren't any ex parte communications, then it just becomes like a moot point. I just think that putting it in the code and calling it out invites attack against the judiciary. We're going to have an increased level of cases. The ex parte communications, if we're sitting at this level and we're engaging in ex parte communications, it's not recusal, it's removal. So I think if you're going to put it there, then that person should be removed because they shouldn't be practicing in the court. I think it's, it's one of those, so I appreciate your position, but I hope that you can understand mine.
Yeah, no, I definitely understand it. I think we're just gonna agree to disagree, or maybe not agree to disagree. We're just gonna disagree on that one. I think that what Cass said rings true. I think what I said earlier rings true. I fail to see a downside of having this in code, and I have not seen it play out in other jurisdictions that have this language where the court gets inundated with a bunch of recusals. Maybe there's a jurisdiction that happens that I haven't seen. Maybe it'll happen for Sioux Tribe, but this protects the judges, it protects the parties. I'm sorry, I just don't see why having this in code and narrowing it to issues of fact, like every other jurisdiction does, is a downside. I just don't see that, so.
Yeah, so working for this tribe in this seat for almost 4 years, I can tell you that everything that is not in writing is skirted in some way, shape, or form, which is why we're constantly addressing it. If you look, and I hope you post our Constitution, our BAI Constitution on the website so that people can see the amount of work we put into this. There are very limited issues found in the updated version with the amount of work that went into this. And corresponding with that, we put in a pretty equal amount of work into agreeing in this. And it is important because, again, personally, I will not be changing my stance on having a Sioux Tribe citizen have the eligibility to sit on one of those positions, and this protects that position. Those people may not be upheld to a bar license, right? Or a bar association in any state. If that's the case, we have the backup in writing. As far as I've seen so far in this tribe and working at the federal level for policy and health-related policy, not having something in writing has been more detrimental than having things in writing and changing it after the fact. So, for instance, this will be new to the entire tribe when we separate the powers. This board, up until the separation of powers, if and when it occurs, which probably will be hopefully within the next year once it goes out to a vote, and then a couple, several months to a year, transition plan, whatever, it'll be new to everybody. And the less we have in writing, the more broad people are going to take their positions. And that goes for the justices, it goes for the OGMA, and it goes for this board of directors. Right now, we operate as one, right? And you're going to have some people transition over to a new government that have been a part of this government for a very long time. And if it is not in writing and could potentially be a removable offense, then it will cause an issue with this tribe. I can guarantee you something will happen. Because while you're upheld to your license, your law degree, I stand firm on her case in point that not everybody should have to have a license to sit on that bench, especially when dealing with our Constitution. And in order to uphold them to the same standards that you would have to be upheld to maintain your license, we have to have it in writing as a law of the Sioux Tribe Nation. And that's I don't understand why we wouldn't have that as a law of the Sioux Tribe. It's just duplication. It already exists. So I don't see a problem with this. I see the more we clearly define boundaries for you, for our legislative, and for our OGMA, the better it's going to be for our tribe as a whole. This is a long time coming, and we know that there are going to be some road bumps. We know that there are going to be some obstacles and some learning curves, but the less we have in writing, the more chances of going right back to this, what has always happened is what's happening. Like, we're not doing that anymore as a tribe, and that's why we're putting this in writing. So I stand firm with legal on this. We have had discussions on this, and I think the majority of the board, the reason this in here, the majority of the board has agreed that these things need to happen. And the Ogama here has the chairman here has stated that, you know, as long as he remains chair, he wants to assign law degree or law licensed individuals, which is totally fine because that would be up to his capabilities in his office. But in case something changes and a non-licensed person gets put on there, they need to be upheld to the exact same standards that you need to be. So you'll.
Okay.
Anyone else? Good, Carrie. Yep.
I just wanted to, thank you for that, Director LaPlante. We do have a judicial code of ethics within our court rules that exists right now, and so I believe that ex parte communications is addressed in there, so it is in writing. The other just.
So excuse me for one moment. That is not the law of the Sioux Tribe. Code is the law of the Sioux Tribe.
I took that, a part of my definition I did steal from you guys.
From the
so,
judicial code
yeah.
of ethics. So, yeah, I mean, the legal profession is a self-policing profession. We would never allow this stuff to happen. So I appreciate your point, and I'm not trying to, I understand. I just do wonder, this section here was not workshopped yet, though, right? This ex parte communications? I think the qualifications of the judges, but I thought that these were all new. This was a new one.
This was briefly workshopped in a February date. We went through it briefly when I breezed through all the
Oh,
code
okay,
changes.
all
And
right.
we've talked
On
about it.
February
We've
17th.
talked about it in different
I just
legal
wanted to make
reports.
sure there wasn't something that I missed. So, and I understand. I will yield.
Okay, let's keep moving.
82-108, recusal of justice. Any justice of the Supreme Court, whether an attorney or lay judge, shall act in a manner that establishes, maintains, and enforces the highest standards of conduct, shall respect and shall perform the duties of judicial office impartially, competently, and diligently. 2, where a justice fails to uphold the standards in 1, has shown a personal bias or prejudice concerning a party, or has failed to remove themselves from the cases required in 82-107, any party may request the recusal of that judge by filing a motion affidavit setting forth in detail the matters alleged to constitute grounds for recusal. This is an amalgamation of looking at different tribal jurisdictions. I believe I even, once again, Carrie swiped some of the language from our current code of ethics, and this is our codification of that.
I don't have any problems with it.
Number 1 might be almost verbatim what we currently have. Yeah.
Okay, is everyone good here? Yeah, let's keep moving then.
82-108, operations of the Supreme Court, rules of procedure. If you have to leave.
This is where you codified the approved by the Board of Directors one, 82-108.
Yeah, the Supreme Court shall employ the rules of appellate procedure as proposed by the Supreme Court and approved by the Board of Directors, to the extent such rules are not in conflict with any applicable provision of tribal code. In the absence of where the tribal rules of appellate procedure are silent, then the federal rules of appellate procedure shall govern to the extent they are not inconsistent with this chapter or applicable tribal code. The rules of procedure shall be posted to the tribe's website. The Supreme Court shall not utilize customs and traditions in cases involving a breach of contract. Such cases shall be decided on terms of the contract and the law governing those terms. So this is not meant, and if it's unclear, we can modify. This is not meant to make it so the court can't create court rules. This is trying to be directed, the same thing we do with our civil and criminal procedure, to adopt a appellate procedure code. But we want the Supreme Court to guide how that code would look. And then the final sentence is also borrowed from other jurisdictions in part. Often the contracts have certain choices of law provisions, and this is intended to cover that scenario more so in the future than currently, because if it's in our court and it's a contract, then it's probably going to be under our tribal laws. But we might have a situation in the future where we have a separated government, we have a contract dispute, but maybe the Michigan is the choice of law, but it's going to be in our court for various reasons, and there's some conflict, then whatever the choice of law of that contract would prevail, and not our traditional rules or traditional teachings, and not our contract law, whatever the law of the contract states was what the court has to decide under. I'll yield, I'll pause, I mean, for a second.
Okay. Any comment here?
Yes, I would just like to, I think that it just needs to be clarified that the Board of Directors' approval of rules of procedure aren't, somehow we need to modify or massage this language in some way for more clarity. Like if I decide, or the judiciary decides to write a rule related to appellate procedure, that appellate briefs can be no more than 30 pages without leave from the court, I don't want to have to bring that to the Board of Directors. Whereas if it is, I'm trying to think of some sort of civil or criminal procedure maybe, that incorporates due process requirements that you have to bring the accused before the court, or they can't be unlawfully or illegally detained for more than 48 hours or something like that. That's criminal procedure that you guys would legislate. I think that's a little bit different. So somehow we've got to work that in here, because I think as written, this looks like all tribal court rules and rules of appellate procedure would need to be approved by the board. With regard to a contract dispute, and I think it's really difficult for me as a Native person and a member of this tribe to, when someone tells me I can't utilize customs and traditions in certain circumstances, it's kind of like, telling me that I can't speak my language, or cutting my hair, or, and you're codifying this. So this is your law. I understand the reasoning. Contracts have specific clauses. Contracts have, contract disputes are decided in a specific way. But I would dare say that custom and tradition has never been a substitute for the law. It's been an enhancement of that, or has a place in every case before our court. We're a tribal court. We're a tribal nation. And so to say that we can't somehow utilize customs and traditions in cases involving a breach of contract, well, a landlord-tenant issue is a breach of contract. I know that we're talking about, probably talking about major litigation and those types of things, but a breach of contract could mean anything. And so I just want to caution that, what are we doing codifying the illegal use, because that's what this does, of customs and traditions within our law?
Could we do this instead? Could you tell me a situation where customs and tradition should take priority over just black and white contract disputes? That way I can understand where you're coming from a little bit better.
Well, I think that when it comes to, we have incorporated custom and tradition into, I guess, Western society due process. A notice and a right to be heard. We've done that as a people since time immemorial, right? We have notified those who need to come before, and we've sat in a circle, and we've passed the talking stick, and we've had that discussion. Concepts of respect and humility, all of the 7 grandfather teachings are not necessarily something that would be used to resolve or resolve or litigate or decide a contract dispute, because you have to look to the black letter law. But I think that the way in which it is decided, with respect and humility, using wisdom, that's how we incorporate those into our decisions. Child welfare law, so a case in which, we are making a determination related to what are the customs and traditions of the tribe. And I'm sure that Judge Dietz has some words here that are not coming to me, but I think that it's not so much a specific line of cases as it is a way of parsing through the legal issues and dealing with them. I'll give you tribal court practice. In my courtroom, when someone comes before the Court of Appeals, it's a much different scenario than it is if you were to go and stand before the Michigan Court of Appeals, where you've got 20 minutes to argue and you need to reserve 2 for a rebuttal, and, and you're timed, and, you've got judges shooting questions at you, and, I've been there, I've done it. In my courtroom, we allow for the arguments to proceed until nobody has anything left to say. And that's just our way as people, right? And so I think that that's where custom and tradition come in. And so I guess what I'm trying to understand here is that how is using custom and tradition in cases involving breach of contract in contrast or in contravention of our customs and traditions, and why does it have to be codified?
So I don't know, to be quite honest with you. So I interpret this section just be, okay, there's a contract dispute being argued before the Supreme Court. It states very clearly what the expectation is. That expectation was not met, which is why the parties are in court, and this is the remedy. That's why I was trying to get you to come up with a situation where customs and tradition would take precedent over just a black and white rule of law. And I still don't understand where a situation like that would come into play in a contract dispute.
We don't use it that way, with all due respect. We don't use it in that way, in our court, in the court that I sit on.
Yeah, that's why I said this is more future planning. We have right in our code. So I think part of what the legal department is going to push towards as we move towards separation is being very clear in the code, like we are in the housing code, of when and how to use our traditional teachings in the decision, maybe not the analysis, but like the decision-making process. I can't think of a specific example because I haven't worked in a lot of separated jurisdictions, but I've talked to a lot of attorneys who have, and one of the concerns, not the judges raised, but the practitioners raised, is if you have a court who tries to supplant the law on the books with the traditional,
Their
whether it's
interpretation
Anishinaabe
of
teaching or whether it's
traditions and
Navajo
culture.
teachings. I've talked to some of my friends who work at Navajo, and they've seen it play out in courts where the courts have tried to do that. And maybe this language isn't perfect, but that is our thought process behind. We want it to be more explicit on when, like in our housing code, when you can use the traditional teachings in the decision, and when maybe the legislature doesn't want that same broad latitude to bring in the cultural teachings in certain aspects. And that's from a practitioner's standpoint and not from a judge's standpoint, because they have a different perspective. So this is where we're coming from our practice in multiple different tribal courts across the country.
Good, do you have something to add? And then I'm calling you, Cass.
How many of your legal team are tribal members?
I don't think it really matters, but it's Josh and I are Sioux Tribe citizens. Yeah.
Because if you have people that are not tribal members, perhaps they would benefit from just coming to our court and observing what we do and seeing how this is a very kind way of doing things as opposed to maybe being overly strict, because our people are not used to being treated, or they're used to being treated one way by the regular courts, maybe even manhandled and tossed in jail at certain times, but we try to be a little more gentle with them because of the backgrounds that we know of and stuff like that. But there's nothing dangerous or, or ill-conceived about what we're doing. We're just doing it in a kinder, gentler way, maybe. And perhaps, I know you have a time constraint with all the things that we have to do in our caseload, your caseload, but maybe if they have some time, they could see how we do things.
And I think all but our staff attorney has practiced at least one case in front of you. We've all argued at appeals in front of the majority of your body. We've seen how you operate. And that, I think we're getting hung up on, and I apologize, maybe it was bad presentation. This is not an indictment on the way you're doing things now in any way, shape, or form. So I don't want to get hung up on this is how we're doing it now. I have, as your legal counsel, I have to take out the current bodies of our court and our legal department and our board of directors, and I have to try to think of all the scenarios in the future where we don't have the same people on the court or the same people on the tribal council or the same people in the legal department, and try to navigate as best I can on different scenarios that might come up based on my experience in working with 4 different tribes and talking to attorneys who work in separated governments in the tribal government world and non-separated governments and 1 branch and 2 branch and 3 branch. And I take all that knowledge and experience from everyone I've talked to and my own experiences, and I try to, as best I can, and I don't always succeed, and that's fine. If I was shooting A+ every time, then I would be making a lot more money working somewhere else probably. But I'm working here because I love working for this tribe. And we try to cover as many bases as we can, and this is something that's been flagged by other practitioners and other tribal courts who are separated as an area of potential concern, and we can continue. This is not being voted on tonight or next week or, as far as I know, anytime in the future, so we have time to continue to workshop this, because I, believe it or not, I do think that there is a lot of room for our Anishinaabe teachings in our court, and I want them to be codified and I want them to be used. I've seen that in other courts. I see that in our court, and you might not believe it because I haven't had the opportunity to be in front of you that much. But part of our approach is in our briefing, we want to try to highlight those things too, because it's important to us too. So in no way do I have the intent of this to stifle the court. That's why it's very, very limited on just the contract law, because I do not want to create a scenario where the court feels hamstringed by the code where they can no longer weave in traditional teachings. That is antithetical to what I believe is best for our nation and not the intent.
Well, perhaps it's just the wording or, the fact that it's being codified that puts a leash on us, so to
It's not being
speak.
codified. I want to make sure everyone's being clear.
Yeah,
These are
okay.
proposed changes and we're workshopping them with you.
Yeah.
This is board driven, right?
Yeah.
This is not the legal department's like, here is what we think. That was in February, and we didn't get to workshop them together because
Right.
the board switched gears. It's fine, they can switch gears. But this is not being codified today. So this is our opportunity to start workshopping on these issues so we can maybe codify it in the future, right? So
Well, thank you for your explanation, and I'm glad that you're being paid enough. I get $3 a day, so.
I am glad that you sit on our bench and I was listening in, right, on this week's Court of Appeals hearings, and you always have great stories to share, so. I'm sorry you only
Well,
make $3.
thank you. It's very important because we are going to be looked at, Sioux Tribe, and what we're doing with redoing everything and getting all of this on paper, and paper burns. But, our traditions and culture remain in our heart and mind. So we're not afraid to lose anything. We'll always have it. But when you put it on paper, it makes it look a little bit strange. Then you can't adjust it per person that you're dealing with. And that's real important. Not every person that comes before you is AI robot. They're different, and they have to be taken as human beings instead of, and we're just trying to We're just trying to very kindly have a perfect court. And I think this whole thing with what we're doing with all of the changes that are being made, I have to applaud you that you're trying to be A+. Because that's what we are.
Yeah.
And we're trying to be that way too. And, you know, and we have A++ people working with us, so we should be okay. Thank you very much for clarifying that.
Okay, so I have Cass, Rob, then Robert, and then we'll take a little break, guys. So go ahead, Cass.
I just want to say briefly,
Can you use the mic?
Or just move it closer, Cass, there you go.
Is that better now? Is it louder? I want to say briefly, customs and traditions do very much have a place in the court, and they are very important in cases such as the child welfare cases. That's why child welfare is not in this section. It's specific to contracts, and hearing that it's being codified is scary, and it seems like it's the first time. Maybe it's not. This is already slightly codified in Chapter 83. It already states, Chapter 83, Section 302, and I'm paraphrasing, it's the effects of agreements regarding dwellings. It states that the provisions of that contract shall prevail. That those provisions, that contract is what matters, that's what's being interpreted, that's what's going to supersede, not necessarily what's not written down on the four corners of that
Can I
document.
ask a question based on that then?
Yes.
So let's say you have a landlord-tenant issue. There's Sioux Tribe Housing Authority versus Jane Doe. So there's a contract in place, a lease. The lease requires the tenant to pay rent. The tenant goes an entire year without paying rent. The tenant destroys the place, has sex offenders over, all kinds of stuff. But let's say you have a situation where you have an appellate court that says, well, it's not our tradition to make people homeless. So that could be a situation where they're explicitly stating we're not getting culture and traditions in the way of black and white contract law such as landlord-tenant.
That would be exactly correct. And if it's not, as, I apologize, I'm not good with names, but as it was already previously stated, if it's not wrote down, we've seen issues before, that would be a case where it is. And having it wrote down here, that is someone who may be a member but is violating a contract and is not a very safe person and not a safe home. And there are other tribal members who deserve and need and would be able to take place in that safe home. So having the contract protections there is beneficial.
Okay, Rob, then Robert, and then Carrie.
So, I'm going to speak on a couple things here. I see this both ways, and I think that we have to be very careful in determining through constitution or code of any situation that our cultures and values cannot be applied. But I also think that we have to be careful that it's not wide open to interpretation from justice to justice or judge to judge. I think that we need to have a system where legislators can have input and the court has input on how to go about this. So the example that was just used, tenant versus housing authority, where someone just totally destroyed a house, didn't pay rent for a year, and had sex offenders in the house and broke all kinds of violations. I honestly would see those as egregious enough actions to where you would have to limit the scope of how you're going to implement cultural teachings, and you would have to rely more on the contract, because those are things that have to be stopped. Same situation though, you have same scenario where someone didn't pay their rent for a year, but maybe it was because they lost their brother or sister or mother or father and just genuinely fell on hard times. That's not a situation where I would turn away from our culture and values and say, look, we're ruling only on this contract. I would say we have an obligation to uphold our culture and traditions, and showing someone grace and empathy in this situation would be upholding those. So I think we have to find some kind of common ground to where we can still uphold our culture and teachings when we execute even a contract. But it needs to be drawn out in a way that there's clear parameters around when we use it and how far we're willing to go with it. Because if we don't, we're going to see unequal distribution and implementation of law, and it's going to lead to inconsistencies not with our justices currently, but over time, because our culture and traditions, there's no one end all be all to our culture. You could see drastically different teachings from pipe carrier to pipe carrier. So where do we go to find out exactly what the teachings are in each situation? We don't have that. And our culture is not set up to be that. It's set up to be, you seek teachings from your pipe carriers and your teachers, and you take what you creator says is meant for you, and you leave the rest. So my interpretation of culture and teachings is going to be drastically different than someone else. One thing I'll say is that I don't want to see our court get completely away from implementing them or having it codified that they can't use it, because I respect all of our court staff and our justices. But I will say that, like Ryan and I have been on opposite sides of the bench, or opposite sides of the courtroom, even arguing a referendum in front of the Court of Appeals. And they did a wonderful job of it. And I'll even point out, one of my favorite people to listen to when they do implement the culture into their decision making is Judge Dietz. And I'll specifically say one time she made an example based on traditionally how our people chose their leaders. And when they lost trust in a leader, they would simply move their belongings and stuff away from that leader's tent and set it up at the next leader who they found more trust in. And that was a perfect example of what was going on in the time of our history of the tribe at the time. And it was used perfectly to make that decision. So I think that, again, we have to be careful to walk completely away from them, but we also have to be careful of leaving it wide open to interpretation. So I would like to see us develop some kind of a process to where legislators and judiciary staff can work collaboratively to put together some kind of format of how and when we implement those and how far they're willing to go. So that way there's uniformity across these decisions that still allow our justices to implement our culture and traditions. Like the example that I just stated, there's a drastic difference between someone completely disrespecting our property and taking up the home of someone who could use it, and someone who genuinely fell on hard times and could use the compassion and empathy of their tribe. So I want to be able to see us execute both our tradition and contract simultaneously, and I think we can do it. I just think it's going to take work.
Okay, Robert, and then Carrie.
I guess I'd just like to say, I haven't had an instance where we haven't done exactly what you just said. We might refer to those teachings in our opinion, but that doesn't mean we totally rely on them for our decision. We normally indicate in addition, the contractual or those types of things in the opinions, as I recall it. And I think what Judge Dietz was touching on is we're never going to change how we treat people in the court. And I don't think that's the intent of this at all.
Okay, thank you. Carrie?
Thank you. So I just, in response to Ms. Ivanen, 83104, applicable law, also says, unless affected or displaced by this chapter, principles of law and equity in the common law of the tribe and tribal customs and traditions are applicable. And the general principles of law or any other tribe or any other state may be used as a guide to supplement and interpret this chapter. This is the tribe's landlord-tenant code as written now. And I just want to say that in practice, this is what we do. We understand the black letter law and what our responsibility is, and I do understand that there will be people that come after us. But to that, I would say that we're very careful about the decisions that we make and the words that we write within our orders and opinions, because that is what's known as the common law of the tribe and case law. So with regard to Director McCrory's statement, I would posit that there's already a system in place. Every time that the Court of Appeals or the trial court hears a case, it is guided by the cases that exist that have already been decided by the Court of Appeals. That's our common law. That's our case law. And so if you go back through that law, you will see how we have used custom and tradition in these cases in order to guide these decisions, and it hasn't been to circumvent the black letter law. And so I just, we really, as a court, have developed in a way that I feel like this tribe and this board should be proud of. And all of our opinions are published. They're usually shared. They've been written about in law review articles with our use of custom and culture and tradition within our courts. And so just understand that you've already codified that the use of custom and tradition is applicable when it's applicable, right? You've done it in the Child Welfare Code, you've done it in the Landlord-Tenant Code, you've done it in many other contexts within the law, and you employ or you appoint or you elect judges to know when to use those things. And that's why, you know, you have a panel of judges too, because we argue about this stuff. And that's, you know, I mean, we make sure that that we put the best foot forward for the tribe, and we realize the responsibility that we have. So,
Thank you, Carrie. I appreciate that. Let's take a 10-minute break. We'll reconvene at 4:30. All right, guys, it is 4:30, so we're back in session. Ryan, where's Ryan at? Ryan, let's continue where we left off, please.
All right, so I put a pin in this one as we want to continue to workshop this language. And as I did with this draft, as we in our department tweak language, we'll pass it along to the court so they can comment and help us tweak it as well. I think we probably did enough damage on this section today. Finality of decisions didn't change. Let's go to something that changed. 82-109, exclusive jurisdiction. Excuse me. The Supreme Court shall have appellate jurisdiction over any case on appeal from the trial court. Only the Supreme Court shall have original and exclusive jurisdiction over any final determination of an election dispute by the Election Commission, and such jurisdiction shall include the power to make findings of fact and conclusions of law and to issue all remedies in law and equity. A little more robust section than the previous language, which was Court of Appeals have exclusive jurisdiction to review decisions of the trial court as provided in this chapter.
Okay, I appreciate it. Any questions, comments here? Okay, let's move on.
82-110, power. The Supreme Court shall have the power to interpret the Constitution, laws, and executive actions of the tribe arising under its jurisdiction, and the power to declare such laws and executive actions of the tribe void if such laws are not consistent with the Constitution. The Supreme Court does not have the authority to hear any cases involving constitutional violations that occurred before the enactment of this code. All cases for constitutional violations shall have a 2-year statute of limitations from when the violation occurred. Maybe is alleged to have occurred. I'll pause.
Any comments? Carrie?
Is the intent of this provision that the Supreme Court would be creating the record? I mean, they would be the trier of fact in this case related to constitutional violations? I'm trying to understand what's being conveyed.
So part of this code change, we haven't got to it yet, is we have to also change our chapter 80, tribal court code. This is a power that is given to the court in the constitutional draft to interpret the Constitution, laws, actions of the tribe, etc. Before we implement this, we'd also have to implement the same language of the Constitution in the trial court level. So it's not, the intent is not for the Supreme Court to be the trier of fact, except for an election, somewhat in the election disputes that go from the commission to them. But that we have to build out the trial court code too, which we haven't drafted yet, to go hand in hand with this. So if there's a constitutional issue, maybe you pass a law, someone thinks it's not constitutional, they would bring it to the trial court and then up through potentially all the way to the Supreme Court.
Okay, and so what this is actually doing then is conferring jurisdiction of matters of constitutional import on the court as a whole, but it gives us the authority, if that's appealed, to actually hear the case, where right now we have none. Unless that jurisdiction is conferred through the laws of the tribe. So I have some language that I could suggest here, and if, in the interest of time, how about if I just shoot you that language?
Please.
And then you guys we can talk about it at another time.
Appreciate it. Any other comments? Okay, then let's move on.
82-110, who may appeal? Any party in a civil action or defendant in a criminal action who is dissatisfied with the judgment or verdict of a trial court shall have the right to file an appeal to the Supreme Court. Excuse me. The Supreme Court shall have the right to accept or deny any appeal from a trial court. This is language from our draft constitution. This basically is our version of certiorari, right? We can file leave to appeal to the Supreme Court But they're not mandated to take that appeal, but they can if they so choose. And that's how the Constitution draft reads, and that's how this code section reads.
Okay, any comments?
Well, this isn't any different than what was there. It's just rewritten.
Yeah, it's just rewritten more or less to match the constitutional language that's being worked on. Yep. Let's see. So 82.112, subject of appeal. Any order entered by the trial court to enforce a final judgment such as a writ of eviction or restitution shall not be used as a basis for appeal and shall not be considered in the provisions and timelines set out under this chapter. One other thing that we need to make note, it's not in this section, but we're building it in this code and in chapter 80, is more explicit code language on how we could do a motion for reconsideration, or what we need to do if we try to execute a writ that is invalid. What I said earlier today when we were talking about this was we believe the proper course would be they can't, if the writ passed the statutory deadline under code, then it's not valid anymore, and they can't execute that writ. So it wouldn't be an order that we appealed. They'd have to go to the trial court, housing or whoever had the writ of restitution, and have to apply again to the trial court, explain why they were unable or didn't execute that writ under the codified deadline, and ask for them to reissue that writ. And if the court doesn't, then they can't execute it. But it's not, I don't believe it should be an appealable order. It should be first decided at the trial court level to make a decision on reissuing that writ. Or if there's a motion for reconsideration and they decide on that, then that would become the appealable order.
Okay, go ahead, Carrie.
Okay, so I think in the context of where this is arising, so a writ of eviction or restitution, we're talking about tribal members living in tribal housing. They don't know anything about motions for reconsideration, or, half of them, that have come before the court haven't even read their lease. And I know because I ask them if they've read their lease, and they say no. And so to expect that the party to the suit, when you're talking about a tribal member who is going to be homeless, if the department didn't do what the department needed to do, not allowing for judicial review of that, the victim is our tribal members. And so I think that this provision, and this is kind of what I was talking about before with the definition of final judgment, while Ms. Ivanen's not incorrect that it says a final judgment or order, if you read further, it says that it explicitly includes a writ of eviction. And I think where the Court of Appeals is coming from is that we don't want to limit the remedies available to tribal members. We're not trying to control outcomes in that way. We're just saying that, we have to understand our tribal members and the community that comes before us and realize that they're not attorneys. I mean, I think Justice Dietz has said several times from the bench, how is a layperson expected to know how to do these things? They don't have the assistance. They're not an entire legal department that, they don't know how to use it. And so really, we take that role of gatekeeper, where we decide issues or whether or not to hear an appeal based on whether or not the law was followed. So whether it was a writ of execution for an eviction, or, we have the ability to grant leave to appeal if they miss the timeline, those types of things. Adding in more procedure for a tenant who is evicted, who doesn't otherwise know how to maneuver through the law, isn't going to do justice for our community. And that's where I'm concerned, is that I don't want tribal members who don't understand how to exercise the rights that they have to be more limited within our own laws.
Okay, Ryan, did the 2008 Constitutional Committee, is this their position? Is this why it's on here?
No, this is not, I should have said that in the beginning, this is not this is not part of the Constitution draft. This is just, this was part of the original code revisions from February that we didn't get to fully workshop.
Assume the board probably pulled on it, maybe?
No, we didn't even get that far.
Okay.
This is our first time having a really
We'll
in-depth
flag it. If the
discussion
board's
about it.
serious about voting on this and codifying it, we can circle back. My interpretation is, you know, or interpretation probably isn't the right word to assign to it, but my thought, why it's not included with the Supreme Court is because that court's supposed to hear more complex issues like constitutional matters, like where one branch of government is suing another branch, that kind of thing, not a landlord-tenant dispute at the Supreme Court level. Maybe not, I don't care. It's up to the board of directors at the end of the day, but there would be a legal remedy, though, if it is in front of the court. It's just there's not an appeal process, so that trial court decision would be final. But if we end up voting on it to potentially codify it, we'll circle back and figure out the consensus amongst the board.
It's that balance that governments have to try to strike, and they often can't strike it because as a pro se litigant, you need to actually be able to, in part, try to understand the law you're arguing, but you're not an attorney, and so there has to be some leeway in it. So I'll put a pin in it, and we'll circle back.
Okay, Cass?
As you said, there is still a legal remedy. There is still the trial court. There is still the full eviction process. There is still all of those multiple steps before,
Appeal process in the housing authority as well.
yes.
Our intent is if you miss your window to appeal, you can't ask to appeal late and explain why you missed it, but you shouldn't be able to use another order that isn't the final judgment to try to potentially circumvent your deadlines. Explain to the court why you missed the deadline, and they have the authority now under the code to allow you to file late. They don't need to hinge it on another enforcement order. They can still hinge on that final order, but make that litigant, even if he's pro se or she is pro se, explain to them why I didn't file in time, right? The court can just say, here's an order, you filed this late, we're giving you an opportunity, please file something by this deadline, why were you late? And then if we understand why you're late, we'll accept your filing. Like, we have that process now. We don't have to use a non-final judgment as a mechanism to appeal, because we already have the ability to ask the litigants, why did you file it late? They can explain it, and the court has the power under this code, under this version and the current enacted version, to allow that late filing. So.
Elizabeth and Carrie?
Yeah, I have I think a simple solution. Instead of a 25-page lease agreement, for people that barely can read sometimes, because they've been damaged by whatever illness that they might have had, it would be nice if that lease could be like 1 page or 2 pages or 3 pages. And why can't we have someone do double duty where maybe there's an office where people do stuff and they're not busy 24 hours, maybe they have a couple hours a day that they're not too busy. And on that lease, it says, if you get anything, like from the court or something like that, go immediately to room 10 in, so-and-so, and they will help you. And then make that part of it, instead of the person going with their 5 kids, instead of sleeping in the park that night, which I saw happen to one woman, and it was cold, and she had a baby, and she was sleeping in the park with a 1-year-old and 2 other ones, our people, because she had the money and she wanted to pay, and they said, nope, your time is up, you can't pay your light bill. And for a $350 light bill, she's in the park sleeping with her kids and the door is locked. So this must never happen to us, because we know better. It's not the Middle Ages. But it would be nice if we had a simple office on the ground floor of the casino maybe, or something, a simpler lease agreement where it just says, if you don't pay your rent, you're going to have a lot of trouble. So if you're in trouble, before you get in further trouble, go to this office and they'll see what they can do for you. It might be very simple. Some of these things could have really simply been solved and saved the court and the attorneys and everybody, we would probably save, $1,000 per case, which would cover the $300 light bill in most cases.
Carrie?
Thank you.
I would just add that the practical reality of this language means that the housing department can violate the law and there's no recourse. So there's nobody to look at it because the tenant isn't going to realize that the writ was not served within the time frame that it was, they're going to have law enforcement knocking on their door. They're going to be, removed from the premises and the locks are going to be changed. And they have no idea that they should have appealed at the default. There's no question about that.
But what also is missed is they have the opportunity to argue their case at the trial court level, correct? And they have a
do.
trial court judge to protect their rights, so.
Right. And
Yeah, I wouldn't necessarily go as far as to say they have no rights and there's not any due process and there's not any protections for them. There's just not that final protection of an
Of
appeal
being
with the
able to
Supreme
appeal.
Court.
Right. And so I think that I agree wholeheartedly with Judge Dietz. One of the things that maybe the Board of Directors might want to look at is revising Chapter 10 with regard to the procedure used by our housing authority on our own people. And then the lease agreement that they don't understand. We've done a lot of work to write things in the legal world in plain language. And so maybe it could be rewritten in plain language so that they understand. And then just some sort of advocacy office where they can get some assistance if they get a notice of termination or something. I think we would have a lot less appeals because we would have somebody to explain to them what's happening.
Okay, Tyler has something he wants to say and Kim wants to make a comment.
So I think we're getting into the weeds here, and I totally agree with you guys, because we've had a couple cases over in Unit 5 over the last few years. One of them was, a family, some kids, their parent, they got kicked out right before Christmas. But what people don't realize is the eviction notices start, like the notices of late penalties and things like that start in July. So there's a 5-month process, and then it becomes this we're going to be homeless for Christmas. Well, we don't want to see that. We need a variety of other solutions in the tribe. We 100% need to address that tribal-wide so that when people are evicted, they have some kind of temporary shelter to get them through until their needs are met. People go through hardships. We shouldn't be throwing them out on the street, unless it's a severe circumstance. We are a tribe. We're supposed to take care of each other. That I totally agree with you. I think that's a system-wide fix. Part of that system-wide fix, I think, will be a 3-branch, because we're going to be separating, we're going to be balancing off of each other. And then the court system hopefully will have more authority to make rulings and hold the tribe accountable as opposed to just the board of directors. Additionally, I think a lot of your concerns would be addressed. I brought this up really early in the discussion when we were talking about the judicial branch. But with the new pathway to the court system, when the separation occurs, we 100%, we need a public defender's office. Because a lot of your concerns that you've brought up here aren't necessarily related to the policy. It's related to the interpretation of the policy and how our citizenship is going to navigate that policy, right? And that can easily be remedied by having a public defender office. And even if we start with one and they're swamped, maybe it can be something where we get new blood in to train under seasoned attorneys, or maybe it's their pathway into the system or something like that, or maybe even becoming a judge themselves one day. But I think, if we focus on the content here as far as the code and law for the tribe, and then work together as a tribe to find out, you mentioned earlier, we don't need 2 clerks. I do think we need some balance there. We can't just rely on one person anywhere in the tribe. But a public defender's office may be a good place to start, as this is a mandatory thing, especially now that tribal members have standing in court. Because right now, whenever somebody goes to tribal court, it's just them and the judge, right? And then our prosecutor. So, without them having the ability to pay. So, I think if we can just, like focus on the content of this and agree that the system isn't going to work without a navigator, just like our healthcare system. It works great, but it's really difficult to navigate without a patient navigator, especially when you're getting referred out into a for-profit hospital system and have no idea how to navigate that system. It's the same thing, right, in the courts, same but different. So it's something that I 100% in this seat will champion for you guys as far as like the budget allocation, because it's something I brought up and I think it kind of got skimmed over a little bit because there was so much coming at us. But it's well past time, it's needed, and I agree with you there. So
Kim?
Well, I was just thinking after hearing all the conversation, sounds like a lot of housing issues, and maybe we need a housing liaison that, like you said, could come in and sit for 4 hours in an office here and help people navigate, like Tyler was saying. You get into that system and a lot of it's, I always say I'm pretty smart, but sometimes you're reading documents that are just, if you ever signed up for unemployment, you'd know.
Yeah.
That's one of the worst.
Yep, Carrie?
Well, thank you for that consideration. I think that, that's much needed for the tribe. As a tribal member, I would say or submit to you that as a tribal judge, limiting things like we're going to talk about in the next few pages, stays, writ review, default judgment review, sua sponte authority, those things are squarely legal, squarely legislative in nature, and they shift the power from the court into the political branches. And so that's why I'm bringing them up and making a big deal about them, because if you limit my review in the first place, you've effectively cut off the ability for us to even hear that case, or us to, to take it as an appeal. And so, Chairman, you're right that, they have that ability at the trial level, but we have a court of appeals so that anyone that is aggrieved of a decision by the tribal court in final judgment can appeal that decision. Now, whether or not that raises to a constitutional import, sometimes it does and sometimes it doesn't, and we know our limitations there as they exist right now, but they still have that right to appeal. And we hear any gamut of cases. I think that not only housing, but just some sort of like advocacy clinic for lay people trying to navigate the court system for issues that are affecting them and things that they don't understand. And I believe, if I'm not mistaken, I remember reading somewhere that there is such a position within ACFS or under that umbrella, to where there was somebody there that was a licensed attorney that was able to help or assist. So I think that I just want to be clear, though, that when we write things into this law that says the court cannot do this, that means the court cannot do it. And so if a writ comes before us, whether it's legal, illegal, written on rainbow-colored paper, we have to say, I'm sorry, the law says we can't hear this, which is a limitation of judicial power. And I don't think that that's what we're trying to accomplish with an independent judiciary.
Okay, we ready to move on?
Yep.
Okay, let's move on.
You want-
And for you guys' information, we have 7 minutes for the end of today.
Yes, we're on page 9 of
So
23.
we're obviously not going to finish this, so if we have any board members who want to potentially codify the courts prior to that secretary election being implemented and being sent out, contact Ryan, contact Lana, get it placed on an agenda. If there's not going to be any effort to do so, it makes no sense to continue to have future workshops on this. I'm looking at all the attorneys in this room, and I'm looking at how much we pay each and every one of them, and it's a big expense. So if you guys want to put it on an agenda, go ahead and contact them. We obviously have the authority to create code to codify the court and mirror what the membership is going to be voting on in the secretary election, but absent a board member wanting to do that, let's just hold off. But let's utilize the last 6 minutes to get done what we can.
And either way, I will still keep working with Carrie because this code needs to be ready in some form when you guys separate. So we'll continue in the background to work on it, whether or not you put it back on an agenda. Because we need to have something in place that incorporates the new constitutional language in the code anyway. And I'll continue to work with the court on that, on the background. 82-113, appeal from a default judgment. There shall be no appeal from a default judgment in the trial, should be, probably should say Supreme Court, without exhausting the remedies available through a motion for reconsideration. After a party has filed a motion for reconsideration in the trial court, and the trial court issues a decision on that motion, that final decision shall be considered a final judgment or order of the trial court pursuant to 82-111. I was just talking with Judge Butts on the break in different contexts. We want to try and build in all codes, not just this one, better records for our Supreme Court, our current Court of Appeals, but also in the future, we need to have, as best as we can, build those sideboards in code that mandate the creation of a lower court record, because it's a heck of a hard job as a judge in the Court of Appeals to be deciding things that have limited record. I know I've dealt with it on appealing election appeals.
Where do we keep our records right now? Let's say I'm a defense
it's not
attorney
that- yeah.
and I want to rely on case law established by the trial court or the appellate court. How do I do that legal research?
Oh, you have to go to our website. They're working on something for like a restatement of our laws, maybe. But that's not what I'm talking about so much as I get in front of Judge Byron and the court on an election matter, but there was no hearing at the election commission. It was just they decided it based on here's my memo, and here's my advice. You can do a hearing, or you can the code allows you to just decide without a hearing, and so they decide. And so the record is literally maybe a 5-minute conversation and a legal memo, and that's a really bad record to deal with as a Court of Appeals judge. And default judgments are much the same way. So we want to build a mechanism, and part of it is going to have to be we educate our citizens on that they have this option. They get a default order on an eviction, or I don't know, in the future maybe they had an employment dispute because they now can sue the tribe because they thought they were wrongfully terminated, but they don't show up for the evidentiary hearing. So the court just defaults on them, and they want to appeal right to the Court of Appeals. The Court of Appeals has no record on which really to base their decision. The proper remedy, initially before it goes to the Court of Appeals, is allow that person to do a motion for reconsideration. They probably can do it now, but it's not codified anywhere. And so how are they going to know, to Carrie's point earlier, how are they going to know that I can do a motion for reconsideration? So we're trying to build some of that language in this code and Chapter 80 for the tribal court. That first, go tell the trial court, please reconsider this default motion for these reasons. I couldn't get to the court that day because my dog got ran over by a car and I had to go to the emergency vet or something. Like, give me the reason and give me the opportunity to go to the trial court and say, give me another chance to have the evidentiary hearing. Hopefully I don't default the second time. Maybe I lose, then I appeal to the Court of Appeals, then they have the evidentiary record built. And this is what this is trying to accomplish for default judgments. That's always a long-winded explanation.
I appreciate it. Final questions, comments for the day before we adjourn? Yes, ma'am.
Tina DeMore. Thank you. I've been quiet today, but the one thing I do want to say is many of the changes that are being proposed here narrow rather than enlarge tribal citizen access to the judiciary. And that's a real concern without available counsel to them, because the tribe in their legislative division here have very able legal counsel. Most people that we see, tribal citizens before us, do not have legal counsel. And while it's kind of easy for us, because we've been so deeply trained to think that it's easy to figure out, for example, how to file a motion for reconsideration, or how to file legal documents, like a brief, which is now required under these rules, it's very, very difficult for lay people to do that and to understand how. So I would just ask that everyone keep that in their framework of consideration relative to the changes that are proposed.
Okay, I appreciate that. I agree with part of that, but as far as limiting access, I think it does the exact opposite. You know, you're giving tribal members standing in tribal court. you guys' docket's gonna explode. Whether or not tribal members have access to legal counsel and whether or not they can afford them is a separate question, but you guys are gonna blow up over there when this is done. So, anyone else? All right, thanks, everyone. See everyone next Tuesday.
The recording